medical admission.
Oh,
Actually, I filed it yesterday, but it's not been listed today.
yesterday?
On
Yesterday was Sunday.
Saturday.
Saturday.
I'm
Okay.
sorry.
Yes, we'll take it up. Yes.
Much of it.
Tomorrow. All of you are getting up now, right? After judgment is delivered, everything. You will have to answer what you have been doing since then. From 2nd of August, what have you done till for 1 month? Please be ready. We are passing an order in today's case, which will apply to your case also. Tomorrow.
Matter pertains to DRT. The matter was matter pertains to DRT and the
Fresh matter.
no lot. It has been dismissed due to the non-representation. It has been dismissed due to the non-representation of the association. We are the restoration filing for tomorrow.
You have filed an application for restoration.
Tomorrow, so that
Restoration you have filed. DRT matter means you know what is Satyavati Tandon. We will relegate you tomorrow itself to the remedy. Be ready. Yes. Yes. Tomorrow.
Medical admission. Friday filed.
You want when? Today, tomorrow. Yes, please be ready, Mr. Nobody comes prepared. We are telling you, putting you to notice. You are approaching this court after 1 month. You will have to answer this question. Nobody is prepared. We are sure nobody has brought the case law. We will decide it today. That decision will bind you also tomorrow. When do you want? Tomorrow? Tomorrow. Today?
Friday, but already
Today. So have you prepared, madam, what you have been doing for 1 month? And how it can deprive you of getting relief? Please get ready.
PG medical admission, last date of joining in tomorrow, Millard. Earlier to them, bench of
Tomorrow.
today, maybe please to Millard, because tomorrow last date, Millard, joining.
All right, let's see. Fresh fighting, Mr.
No, Millard, earlier to the bench of Kisanogo court.
Then, Mr. You, please, what were you doing? You knew, when did you know that last date is tomorrow?
Yes, 31/8/2023. I
You
know,
knew.
Millard. I downloaded on 1/9/2023. So that Millard.
But we will take it up tomorrow. We will permit you to join. There is nothing. If because Mr. Rao has to be put to
Yes, sir.
he must not have brought the file also. How can we take up today?
Already I have
Only those matters today will be taken up of which Mr. Rao has noticed.
I have already informed him.
Fine. All yes. Tomorrow?
Pick up tomorrow.
Tomorrow. Yes. In fact, all madam.
For tomorrow, medical admission matters, your lordship. Seeking for tomorrow.
Get ready. The question of delay in approaching the court. Fine. We are putting everybody to notice, right? You just come like this, and at times you don't know what is the prayer also. Please.
Tomorrow.
Lordship say in my matter, Millard, covered judgment of Honorable Supreme Court.
Sorry, what? This is PG is done, right? Tomorrow. PG, your PG matter is tomorrow, right? Then what is somebody some other mention memo? Arey, Mr. Prabhakar, you made a request for PG. It is coming up tomorrow. Then what else? Covered by Supreme Court, which judgment?
WP number 944 of 2020.
Another mention.
Yes.
We will take it up a little later, Thursday. Thursday is a holiday.
But last date of joining is only tomorrow. So that
We have granted tomorrow, no? So we have only one mention memo.
only one.
So coming up, we told you tomorrow. Yes. 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 Yes, senior come.
Pass on this small synopsis and chronology, my lord.
No, nothing, no synopsis. It is admission. And you say that this WP is pending before single bench only.
It is not listed till now. I just pass on that.
No. WP 913, it's an interim order deferring the proceeding, obviously under a misconception of fact that WP 913 of 21 is pending before division bench, which is not so.
Not so, my lord.
So then you bring this fact to the notice of learned single judge. We will request him to pass appropriate orders.
I leave it
Let's
because
yes.
only
This
thing, my lord,
intra-court
will
appeal,
post along. I just pass on synopsis. That's 913, my lord, is yet to be posted before learned division bench as per the orders of the registry.
division bench.
It has not yet been listed. It has been
No, no,
referred.
what is your point, mister?
Lord,
You have taken a point that 913 is in fact before single judge, which the single judge has
not
not
yet been
taken
listed.
note of.
It's not yet been listed.
It
That's
is
the reason I just passed on the synopsis, my lord.
What synopsis, mister?
Why you have asked for it is that especially the third page, my lord, chronology.
No, no, no. The only question is, mister, we are senior counsel, whether 913 is pending before division bench or single bench. From the memo of appeal, if you have seen, whosoever has settled, you have taken a ground that 913 is before single bench.
Lordship may.
So we will,
I'll file appropriate.
yes, we will say so.
913 is before division.
This intra-court appeal has been,
913 is before, it is a reference, my lord. There is a reference.
I
to
still
division bench in
I
913.
stated so in my synopsis that 913 Honorable Learned Single Judge on earlier occasion synopsis dates were at third page. That it was referred.
yeah, but you said single bench.
Yes, sir, that's the reason, Your Lordship is. You may see page 3 where chronology.
At least, mister, on facts, there should be no
but
variance from
that's true, but
when a senior counsel is appearing. That's what we expect.
It's chronology and faster.
Treated as still.
Item 6, my lord.
Where is
Record
the order of reference, Mr. 913? Order of
I have not
reference.
the petition, but I could not get a copy.
Where is the order
I
of
am
reference?
also not the.
We are not petitioners.
What basis you are saying that it has been referred to division bench?
That is mentioned in the order, and you may see the synopsis
No,
point.
no, no. He is saying that it is pending before single bench. You are saying it is before division bench.
They are also
So
saying,
if you are proceed, tell us, then you said that it's a reference. So please produce a order sheet of WP 913 to show that it is pending before division bench.
6 my lord, you may
This
kindly
intra
see 6
appeal, this intra-court appeal, unfortunate, mister. Simple question you are asking.
6 my lord, that is what.
Six is the order.
6 in the synopsis that is furnished by them. It also shows
Mister, what did we ask you?
23/2013, there is a reference order. That is what is mentioned by them
When
also.
it's a reference, then mister,
Yes,
But not my
what
submission.
is wrong with the order?
No, it is
You
not.
file an application before single judge.
Appropriate clarification, I'll seek it.
This mark the presence with consent of the parties, matter is heard, condone delay allowed, then with consent of the parties, matter is heard finally. This intra-court appeal has been filed against an order dated 14/7/2023 passed by learned single judge, by which learned single judge has deferred the proceeding in the writ petition till decision of WP number 913/2021. Learned the senior counsel for the appellant submits that by an order dated 20th March 2023, learned single judge 20th March 2023 passed in WP number 913/2021, the learned single judge has referred the matter for to the division bench. However, till today, the matter has not been listed. Full stop. He submits that he be granted, learned senior counsel for the appellant submit that the appellant be granted to submit an appropriate application before the learned single judge. Full stop. In view of aforesaid submission, the appeal is disposed of with the liberty to the appellant to move an appropriate application before the learned single judge.
Much of it.
Yes, next.
May I please, Your Lordship? My lord, petitioner is the appellant. The petitioner is the appellant before the my Lordship.
We know it.
Yes.
uh,
The order passed on 16/6/2023 has been vacated by an order dated 8/8/2000.
who appears?
I'm appearing behalf of the 1 to 3, my lords, respondent corporation.
my lord, I am appearing for respondent number 4, my lord.
What happens if I stays vacated his petition right? He should live without electricity, right?
My lord,
Because he is not the owner.
my lord, may I submit this?
This is not the this thing, Mister. Right to electricity is one of the basic facets and forms integral part of Article 21.
But,
This you may be the owner. That fight it out with him in civil suit.
Yes.
may two submissions,
Yes,
my lord, then I leave
please.
it to your lordship.
Please.
We are brothers, my lord,
Ah,
and we
very
have
good.
partition.
Ah.
But, he being elder, my lord, he occupied my property. My lord, when there is a confusion, I approached this court, my lord, and got it surveyed. My lord, at the time of taking,
You know, we are assuming for a moment that he is in rank trespasser. You are the encroacher. You are the owner.
no, my lord,
That doesn't affect his right to seek electricity.
Not,
You can evict him in accordance with law.
my lord, that doesn't stop there. My lord, he digs a borewell, he goes to electricity department, he gives an undertaking saying that this
He-
bore-
You are the owner, right?
yes,
He is in unauthorized possession.
yes.
Can you throw him out with the help of police authorities? No.
I am not throwing out.
So then take recourse to law. So long as he is in possession, in our opinion, he has a right to seek electricity. Seeking an electricity connection does not create any title in favor of anybody. We will clarify this.
Lord, I'll accept that. My lord. He gives an undertaking saying that this particular borewell,
He has given, we have seen that.
Lord, something obtained under misrepresentation and
If
suppression.
there is any objection, the authority can cancel. This is the undertaking furnished by him.
My lord, he specifically says this particular borewell is in survey number so and so. If any objection is there, I will be liable and service connection may be disconnected. This is undertaking on the basis of that undertaking.
No, he had applied for survey number 492/2 and connection has been granted 492/2 only.
Yes, my lord, in the affidavit, he says it is in 491/1. In the suit, he says it is in 491/1. My lord, a person.
Yes.
My lord,
You also know the legal position, Mr. You
Yes,
want to
well-
argue? We will
I
hear.
am not arguing for the purpose of argument. I am only placing this before your lordship. Sir,
Undertaking.
my lord,
We have understood he is bound by his undertaking. Therefore, no electricity connection can be provided to him.
my lord, a person obtaining something under suppression and misrepresentation, my lord, can be allowed to do that. Only my submission, my lord. Beyond that, my lord, I have.
The presence. With consent of the parties, the matter is heard. Finally, this intra-court appeal has been filed against an order dated 8/8/2023 passed by learned single judge by which stay granted in favor of the appellant on 16/6/2023 has been vacated. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the appellant stroke petitioner filed a writ petition seeking a direction to respondents 1 to 3 and respondent number 5 in the writ petition not to disconnect electricity supply to the petitioner service connection. Full stop. The learned single judge continuation. The learned single judge by allowed to he cannot cause damage to his standing crops. Full stop. Therefore, the learned single judge in the peculiar facts of the case ought not to have vacated the ad interim order. Full stop. The interim order. Full stop. The paragraph for the aforementioned reasons, order dated 8/8/2023 passed by the learned single judge is set aside. The official respondents are restrained from disconnecting the electricity supply to the premises in question during the pendency of the petition. Full stop. It is made clear that observations made in this order have been only made for the purposes of deciding this appeal and shall have no bearing on the writ petition which is pending before the learned single judge for adjudication. All the contentions all contentions are kept open, which can be which can be raised by counsel for the parties. Accordingly, appeal is disposed of. Yes.
But may I make one request, my lord? Lordship may also say suit, my lord. Suit is also pending. Please approve.
So the right to, madam, you have written is fundamental part of this thing. Mere grant of electricity connection has no bearing on the question of in respect of the property, which in any case is pending adjudication of a suit. Pending adjudication in a suit. Next.
Oblige. Oblige.
Yes. Yes, Mr. 6 September.
Yes.
This matter is coming up 32H.
This may be,
Mr. Rao,
Yes, sir. Yes,
6 September.
this may be tagged along with those matters. And there
You
is an
have
ID.
the order? Order. This order you want to be passed,
Same order may be passed, my lord.
which there is an interim order.
Interim order is there.
Interim order is there.
I have filed, my lord.
That interim order we will pass for the sake of which page, Mr.
My lord, page number, my lord.
Write everything, madam. Interim order.
97.
This is the interim order and list on 6th of September 2023 along with WP number 23100/23. You will have the order, right? We're keeping it.
Obliged, my lord.
Which other case, Mr. 32H is item 7, Mr. Prabhakar?
Item
Huh? 7. Item 7 also this order. 7. Yes. Next.
May I please, my lordship? Medical admission matter, my lord.
Yes. Yes.
My lordship,
What is the prayer?
prayer is
No, you will have to answer all this bunch we cannot entertain, Mr. Right? You have pleaded in the petition that on 2nd of August 23, you were declared as non-local candidate. Why were you waiting till 31st of August to file the petition? Delay of this this magnitude of 29 days in academic matters where everything is time bound is fatal. And in our opinion, you are not entitled to, prima facie opinion, you are not entitled to seek the relief claimed in WP. Please tell us, what is the law?
my lordship's petition is my lordship's petition is a student, my lordship.
The student can do anything, right?
My lordship,
And you can seek admission in the month of December also. Why have you come? You have come a little early.
my lordship may consider
No consider. We are passing an order. This can't be done. Yes.
Even on merits also not entered.
See, you should see. Action is published. 2 months. There is no representation. We have taken a similar view. I was part of the bench which had passed an order in Karnataka. I am bound by my own view. We are referring to it also. And apart from that, Supreme Court decision also. Yes. Yes, matter. Petitioner is an petitioner with consent of the parties heard on the question of admission. Mr. Rao.
Yes.
In this writ petition, Mr. Rao for respondent number 2 and 3. in this writ petition, comma, the petitioner inter alia has prayed for the following relief. Quote. Paragraph. The petitioner had appeared in the NEET undergraduate examination, which was held on 7th of May 2023. The petitioner was declared successful in the aforesaid examination and had examination. Full stop. The petitioner was treated as full stop from averment made in para 5 of the writ petition. It is evident by the petitioner from the averment made in para 5 of the petition. It is evident that petitioner was declared as non-local candidate. Paragraph 5 of the petition is reproduced below, extracted below for the facility of reference. Quote. Para 5, you first write, delete, what is the sentence? Delete. Para 5 of the writ petition reads as under. Quote. Thus, line below, thus it is evident that the petitioner was declared a non-local candidate on 2/8/2023. Full stop. Then when that petition was filed, will you get the date batch 33B? Right? The students, the students who are similarly situated like that of the petitioner filed Zero. Full stop. And UP Power Corporation versus Ram Gopal 2021 bracket close 13 SCC 225 paragraph. We are aware about the paragraph, delete. The normal rule is that when a particular set of persons are given relief by the court, comma, all other identically situated persons need to be treated alike by extending that benefit, and not doing so would amount to violation of Article 14.
Mine also same, Lord.
That he is not entitled to similar relief. See, problems that so let's say that's why. Yes. Yes, 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 madam.
May please your lordship.
Ah, yes.
Sir, I am
sir.
the petitioner. Your
What is the relief?
Relief is the only to admit, declare me a local candidate
Ah.
in B category and C, Lordship. Because I was already allowed in A category, that is convener category, sir. In writ petition 22038
No,
of
no.
2020.
So when were you declared non-local?
I was declared prior to my writ petition, Lordship in this
When
matter.
date? This all
20
missing in the writ petition, Mister. We go through the writ petition. That's why it is as vague as possible because it's inconvenient for you to plead the facts.
Yes, sir.
So you are missing. When did you? Same principle applies. When were you declared as non-local candidate?
26, Lordship.
Huh?
26/8.
How?
Thereafter, I filed
No,
a
Mister.
22038.
Please appreciate. If,
Right.
I mean, the just petitioner in previous case was declared as non-local on 2nd August, right? The list was published. You are not an exception. You can't be treated as on 26/8. You must have been treated on 2nd August also. No, fill an affidavit, Mister. Along with the communication that you have been treated as non-local.
I was,
Affidavit.
yes, yes, Lordship.
Date you have not been given.
My
We have-
writ petition already allowed and I was allowed as a local candidate. That is,
Well, Lakshmana candidate is, my lord, he wanted the 85% reservation in B category. B category, there is no reservation. It's a management seats. Where candidate from all over India are eligible to compete B category seats. He want a special case, he should be treated as a local candidate.
No, he is local candidate in this.
B category.
B category.
You are not.
They want exclusive order from the honorable court.
No. Which provision prohibits them from this thing? He has not challenged.
My lord, notification is there, my lord. 114 were the rules, my lord.
So how contrary to rules a relief can be granted to you unless you challenge the validity, Mister?
Yes, Lordship. Entire
Which rule? Mr. Prabhakar, which rule? Mister, you have not challenged the rule. We will dismiss the petition saying that in view of this rule, you are not entitled to be treated as local candidate and you have not challenged the validity of the rule, therefore no relief.
That is the B category, Lordship. First
Whatever category.
A category, I was allowed. I was allowed as a local candidate for the admissions. And from
There is Mr.
after
Pratik.
10th class, I
Read prayer clause. You have not anywhere said that B category, C category.
yes,
Read. This is what is most confusing here, that half a page prayer doesn't make sense because your typist or the person who has typed this petition has typed the relief. You have not chosen to read it even today. Please read. What does it make sense? Read again. For our benefit, we have not read it.
yes, it is further pending disposal of.
No, it is there for
Yes, it is there.
page 10. In page 10.
Right, and honorable court may please to issue writ order direction, particularly in the nature of writ mandamus, to declare the action of the respondent number 2 not considered in petition as a local candidate in Telangana state as per rank shown in the merit in the connection with the NEET admission petition as illegal or arbitrary. And so articles are put in 1921 in India, and consequently direct the respondent number 2 herein provide the admission to the petitioner by considering him a local candidate B and C categories.
So what is So what is B category?
B category is the management category. And C also category.
C is what?
C is the more cost than the B, sir.
Huh?
More cost than B category.
NRA category. C.
That is NRA and
NRA. So what is the requirement? Which rule, Mr. Prabhakar Rao?
Right now, I do not have lots, but kindly put it tomorrow. Right, yes.
plus.
No. If Mr. Please examine. You must have been. Is it your case that under which rule you are entitled to be treated as local candidate?
In 3 lots.
Huh?
3. Roman 3.
Roman 3?
Yes.
Then the division bench decision is against you. We have already held that.
Yes.
Division bench decision is against you. We have held in that division bench decision that none of the cases of the petitioners fall under rule this thing. Until you challenge the validity of rule, you cannot get anything.
The last application, not the writ petition 22038.
Mr. Rich, we are not, please understand that we are not sitting here to convince you. Our job is to pass an order.
Yes.
Take a flight to Delhi. We will make the order available to you. Correct? We will dismiss it saying you are not telling us the rule. You are not you have not told us when this thing, you are treated as non-local candidate, this query was put, you did not answer. There is no material. You didn't say that I will place it on record that on 26/8 I was declared as non-legal. That is you are not doing except for making verbal submission. Secondly, which rule you are entitled, you don't know. Then thirdly, that rule you have not challenged. What can be done? Thank yourself for drafting such a petition.
Tomorrow,
And go to Delhi then. Let him go. What to do? This is all vague, not orally telling, not answering.
my submission, Lordship, I was already declared as a
That's
local
why
candidate.
when we say that we will dismiss you, immediately understand. So long as we are trying to tell you that please amend the petition, challenge the rule, you don't get it. The moment we say that we will dismiss, immediately you understand what is to be done.
Yes, Lordship. Tomorrow,
The presence.
I will amend them. The permits that.
We, from perusal of, we have heard learned counsel for on the question of admission, petition is admitted for hearing. Notice. Yes.
Public.
Yes. Madam.
The petition is filed, agreed by.
No. Again, madam.
The medical matter.
When,
Hello?
what was the last date of uploading?
Last date of 27/10/2022, madam.
First phase of,
Madam.
he did not exercise, my lord.
22, how can,
My lord,
he doesn't know.
she did
what
not
to-
secure the sponsor letter within the time, my lord, so that he.
Madam, we have gone through your petition. What was the last date for uploading the application? That is missing. And why you did not upload it, that is missing. Student MBBS is all right, but students have to participate in the examination as per the guidelines framed by the university, right?
Yes, my lord.
So you, all others uploaded, why you didn't upload? What is the date? When have you filed the petition? This is all vague, madam.
We have
The
uploaded.
petitioner should thank for engaging you. This is all. What is the last date of uploading?
My lord, petitioner has made a representation letter along with documents, my lord. Representation letter is in page number 22, my lord.
23 paragraph.
It's a covered order, my lord.
You don't, you haven't read, madam, the petition drafted by you.
My lord, kindly post it tomorrow, my lord.
Paragraph 5, you have said that it's 12.8. Brother is pointing out, you don't read your petition itself. What pity? What a pity.
I have read my 12/8/2023 last.
So why you did not upload?
My lord, we have given a representation letter, my lord, kindly.
No,
see
why
page
you did not?
22, my lord.
Madam, what is the, why you did not upload till 12.8? Then comes the
We
representation.
did not get this.
You
answer letter
withdraw.
at the time, my lord.
You
Responded.
withdraw the petition, approach Mr. Rao, he will do whatever. We can't see, if you depend on us, we will go by rules. The rules are binding on the court. This Mr. Rao can do anything. He can admit you even today also.
My lord,
Go there.
it's a covered order, my lord. Covered order is in page number 32, my lord.
No covered order, madam. Each case is different on the facts of the case.
Kindly see page number 33.
2 rounds of counseling are over, madam. In that case, the petitioner.
My lord, respondent number 2 is not allowing the petitioner to permit this
No.
web options.
No, madam. Why have you come after this order was passed on 22nd August 23? Why were you sleeping?
No, my lord, she did not
sleeping,
acquire the
right?
sponsor letter. Though she have made a representation, she did not acquire the sponsor letter, my lord.
Mr. Rao, should we pass a similar order like this or? Huh? All right, similar order. Page 32, certified copy today. No opinion on merits. It must be there. No merits. Like page 32, certified copy today. Yes. Madam, do better. Be more accurate in drafting things, right?
Yes, my lord.
It is same as that of item 4 last.
Oh, all right.
It's not so, my lord. Here, my lord, the delay occurred, my lord. His grandfather was not well. And second thing, his son-in-law expired, my lord. And third, theft taken place in the locality of 4 to 5 hours.
Where? Which paragraph?
That's what I have, because that delay, Lordship will proceed tomorrow. I will find
No,
a better affidavit.
no.
Because, my lord, I was under the view.
The theft doesn't mean that.
Theft is occurred, my lord, in the total locality of 4 to 5 houses. Rego for of flocks.
No. Mr. Theft happened. So this thing, you were declared as non-local candidate when?
After
yes. Identical order, Mr. We are sorry. We cannot take different view in different cases.
But this one, what, man? That father was seriously ill, man. First thing. Second, son-in-law passed away, man.
When passed away?
Death, man. Then,
No. The petitioner's son-in-law passed away. Then
father,
petitioner had to apply. Petitioner had to apply. It has nothing to do with son-in-law.
The family, my lord, in the family, the son-in-law passed away. His
Son-in-law had not to apply for being treated as local candidate.
My lord, my grandfather was not well, my lord. After that,
Everybody's grandfather, all children's grandfather are not well because they are senior citizens, right? It cannot be, Mr.
Lordships are aware in the joint family, my lord, generally.
You file an affidavit, the order will be the same.
File tomorrow, better affidavit, my lord.
Not tomorrow, day after. There's no urgency. When a query was put to learned counsel for the petitioner, no, delete. The petitioner is a candidate who has passed the NEET UG examination, which was held on 7/5/2023. The petitioner was treated as non-local candidate on 2/8/2023. However, by an order passed today in WP number 24378/2023, we have declined the benefit of the common order dated 29/8/2023 passed by this court in WP number 21268/2023 to a student. Full stop. Paragraph in the instant case also, the petitioner has filed this petition only on 1/9. When have you filed the petition?
Yes.
1/9/2023. 1/9/2023. Full stop. Thus, the petitioner is guilty of inaction for nearly period of 1 month. Full stop. At this stage, learned counsel for the petitioner prays for adjournment to enable him to explain the delay caused in filing the petition. List day after. List tomorrow. Tomorrow, Mr. You said tomorrow.
Milad, on 31/8, Milad, your lordships have passed, Milad, a proceeding sheet. What, Milad, enabling me to examine, Milad, whether this particular matter is covered by a judgment rendered by the Rajasthan High Court.
He was not clear. Mr.
Milad.
One thing, young person, at times we want to tell everybody, not to you. All times you owe a duty to be fair to the court, right? All times.
Milad.
Because we respect you and we treat you as an officer of the court. You have a distinct status. You have been telling us covered. Now, this thing, the state of Telangana had issued the impugned notification on the basis of the
NCT notification, Milad, which has been quashed by the Honorable Supreme Court.
Quashed by the Honorable Supreme Court. In this case, the examination was held on 12/6/2022. Already 12/6/2022 examination has already been held.
Yes.
And what has happened to that examination?
That the results have been declared.
Declared.
Yes.
So when have you filed the petition?
This was filed on 6/6/2022.
6/6/22.
Yes.
And when the results have been declared?
That it's subsequent to this, Milad.
Where?
We filed it.
Date. Mister, you also don't know.
Milad, by that time, Milad, we have filed counter, but it is not.
Result has been declared when? You are the authority, you don't know the
results, Milad, 27th June 2022. Page 77.
What has happened to this thing? You have failed, right?
No, Milad, this is not a case where we have participated in this. We are the diploma holders. We are aggrieved by the state allowing the bachelors.
Mister, whatever is this process is over. Supposing this notification is quashed, who will be affected?
The bachelor.
No, we are asking you.
Holders, bachelor degree holders.
Where are
the diploma holders?
Where are they in the petition?
May I only, Milad?
No. Where are they in the petition? Which respondent?
The bachelors, we don't know, Milad, who are bachelors, because, Milad, may I?
No means result has been declared. You should find out. In the absence of aggrieved persons, we cannot grant any relief.
May I only submit this, Milad? The rule has been challenged. Rule, Milad, may have to go because in light of the Honorable Supreme Court judgment, Milad, quashing the NCT, rule may have to go. Milad, so far as the notification is concerned, they may have to take steps, Milad. I would not press on that.
Interim relief, no interim relief can be granted.
No,
to you.
Milad.
We will examine it the ledger. Heard petition heard on the question of admission.
Now, Milad, I'm sorry.
The petitioner have assailed the validity of the government order dated 23/3/2022 issued by Government of Telangana by which guidelines have been issued for conducting Telangana State Teacher Eligibility Test under Right of Children to Free and Compulsory Education Act 2009. Paragraph. Admittedly in pursuance of the aforesaid notification dated 23/3/2022, the examinations have been held on 12/6/2022 and the result has been declared on 27/6/2022 already. Full stop. The selected candidates are not in full stop. The petitioners filed this writ petition challenging the validity of the rule on 6/6/2022. Full stop. Therefore, at this point of time, especially in the absence of selected candidates before us, no case for grant of interim relief is made out. Accordingly, same is rejected. Petition is admitted for hearing.
Milad, this is not a recruitment notification, Milad. This is a teacher eligibility test.
What interim relief you are seeking?
Milad, my respectful submission is
what interim relief you are seeking?
Main relief itself, Milad, is that.
All right.
Milad,
we will amend it. Correct.
Sorry, I'm sorry.
Correct. We will amend ourselves. No problem.
I apologize.
Thank you for correction. Has been held, etc. Right? In the absence, delete. Delete absence. The petitioner, by way of an interim order, has sought stay of impugned
judgment.
We will
I
consider.
filed IA, my lord, to explain
Let IA1 of 23 be listed for consideration in the first week of October 23.
I'm grateful.
Yes.
But these are respect of Ganesh person, Ganesh ID.
Hmm.
But I have made a counter affidavit on behalf of the TSMC today. But what I was informed report, but earlier the last year, what 3 lakhs KIDs were.
Who is appearing for petitioner?
And I am appearing for petitioner. In my petition, counter is not.
But Thursday, if your lordships have it, but for the
Item
reason,
number 12.
for the reason, my lord, till yesterday, my lord, they were busy in distributing the 2-bedroom houses, my lord, for 10,000 people. The GHMC staff.
Oh.
But
So when will you file counter, Mr. They have to be decided, you will agree.
but day after, no, I'm sorry, my lord, I'm sorry. I only request my lord, to have it day after tomorrow. my lord.
Day after. By that time, you will file counter.
One counter is filed, my lord, additional affidavit is required to bring it. to-
Yes, petitioner in this petitioner, you are an association, right?
Yes, correct.
Petitioner, which is an association of Ganesh idol artisans, seek a direction, challenge the inaction on the of the respondents 1 to 5 in not considering the representation dated 18/6/2020-22, seeking permission to sell Ganesh idols made with plaster of Paris prior to 2019. The petitioners in addition seek a permission to sell the same during the ensuing Ganesh Chaturthi celebrations in the year 2020-23. Mr. Harendra Prasad, how many idols you have? You should tell us the number also. It's vague.
That is my writ petition, your lord.
Madam, you should disclose if
Yes.
you had constructed during COVID period.
Yes.
What are you doing? Number of idols apart from validity. This all covered. If you study, you will find the answer. What is it?
Milord, I am
File as
Yes.
number 10, Milord. I'm appearing from video conference, Milord.
Yes.
Yes, Milord.
Yes,
Already
Mr. Prasad is seeking time till day after tomorrow, so we are adjourning the case. We are only telling petitioners council, so all is decided, but they have not studied and they will only argue.
And Milord, the government is not deciding in this matter, right? In spite of the Supreme Court direction, Milord.
Yes. You will. Day after tomorrow, please appear in person and tell us the guidelines. Mr. Harendra Prasad, learned senior counsel, whatever. It's attached to so and so. Praise for short accommodation to enable him to file a counter.
I have filed a counter, additional affidavit.
Additional affidavit. List on. You find the answer, Mr. We already have the answer. Today also we can dictate the order. These people are not ready. They will.
I informed this court, my lord, that we had provided 3 lakh clear IDs last year. I wanted to place the figure before my lords for this year to avoid
This is all
IDs.
plaster of Paris, all for this thing, environmental pollution. This all.
We have created 25 bail
List
records
on.
for
List on. Tomorrow, what?
day after.
So tomorrow, Milord, because already the POP ideals are being.
No, Mr. We don't have any problem. The thing is, these he is praying for day after is what, 6th?
Yes.
No, Mr. It can't be 6th.
So far as
Friday.
No, it can't be, Mr. 6th. We already have 102 cases. It can be either 5th or 8th, whatever choose.
8.
8th, Mr. 8th we will decide. 8th we will decide, Mr. We are ready today also. After final order in this case, also we are ready. 8th December. 8th September.
I'm deeply obliged for my.
Item 11, 12.
Day after.
All right, same order. Where is that, madam? Next fight.
guidelines are under chart.
1 minute. We know that. See, Mr. You should better study. Have you studied it? It's issued by Central Pollution Control Board. It may have been examined somewhere. Challenging saying that it is violative of Article 1421 is fine, right? But you have to substantiate this. Anybody can say violative of Article 14, this thing, 19, 21. In this writ petition, next case, 12. Petitioner has assailed the validity of the revised guidelines issued by Central Pollution Control Board for immersion of idol, totally banning plaster of Paris idols. Full stop. Mr. Prasad, what do you want? Additional affidavit? Counter. Mr. Prasad, Harinder Prasad, what? Prays for short accommodation to enable him to file a counter in this writ petition. List on whatever, 8th of September 20.
Completely obliged. And no further time will be granted, Millard.
No further time we will be granted and we will decide it. You are for the petitioner.
No, I will
No,
repeat
he is a
petition.
third party. He is an intervener.
Intervener. So these people should be ready. We will decide it on 8th. Forget Mr. Prasad. Once indulgence has been shown to him, if he is not ready, you are on a question of law. Argue. How Article 14, 19, 21 substantiate your submissions. Legal issue. Yes.
Madam, for the respondent
On the question of admission, petition is admitted, record Peru's petition is admitted for hearing, counter if any, be filed within 6 weeks. Six weeks further time, you say, further time. Same order. Petition is admitted for hearing. Interim order granted on 3/8/23 shall continue. 6 weeks further time is granted to file counter. Counter 6 weeks time. Interim order is already there. Yes. 6 weeks we have granted. That's why senior counsel. No. There is already an interim order in your favor, right? So we have said interim order shall continue. Yes. Mr. Please appreciate that today have you seen the final hearing list? Which case is the oldest one? 98. We can't hear even if they file return tomorrow. We can't hear it day after. Fine. There is an interim order. Nothing happens. Everything is subject to the result of the petition. Yes. Yes.
I'm for respondent.
So two questions, Mr. You are respondent, right?
Yes, ma'am.
Whether petitioner was heard, which provision empowers Lokayuk to stop construction? Act, Lokayuk Act.
There is no act. So in this case, my lordship, there is a conflict between it.
You don't have any power. Well, order. You have the power. You are municipal corporation, right? Who are you?
Lokayuk, my lordship.
Lokayuk. Then who appears for municipal corporation? Nobody. Then
Surendra Reddy is the municipal corporation.
Not appearing.
I am appearing for respond number 2, my lord. In this case, my lordship.
No, corporation.
Corporation Surendra Reddy.
Huh?
Mr. Surendra Reddy.
Not appearing, right? Fine. Under which provision you have power to stop construction? And how it can be allowed to be fettered by a direction issued by somebody else who has no power? You have your independent power. You means Mr. Reddy.
Yes, madam. Corporation. Warangal
Corporation. Yes. Mark the presence.
Both is fine.
You are a corporation, Mr. Reddy.
Very fine. Very fast.
So how Lokayuk has jurisdiction to stop construction? No, if he commits, he holds a public office and guilty of misuse, and then you approach against him to Lokayuk.
My lordship.
No, this order has to be quashed because it is from the dictates of somebody else who has no authority in law. You, Mister, you will be at liberty to approach
Yes,
this
sir.
Greater Warangal Municipal Corporation, not Lokayukt.
Yes, I have already approached. I filed a representation. Last week, I did direct for dispose of.
In this writ petition, mark the presence with consent of the parties, same is heard finally. In this writ petition, comma, the petitioner inter alia has assailed the validity of the orders dated 28/12/2022 passed by Lokayukt State of Telangana and order dated 31/3/2023 passed by Greater Warangal Municipal Corporation, by which the appellant has been asked to stop further constructions until further orders of Lokayukt. Paragraph. Admittedly, the Lokayukt under the provisions of it is considered by admittedly under the provisions of Lokayukt Act, right? Which year? Lokayukt Act, which year? Find out, madam. They don't know. Lokayukt Act 1983, Lokayukt has no power to entertain a grievance with regard to construction. Full stop. Therefore, full stop. The aforesaid legal position has not been contested by learned counsel, who appears for Lokayukt as well. Paragraph. Therefore, it is evident that the Lokayukt had no authority to issue the impugned order dated 28/12/2022, and consequently, the Greater Warangal Municipal Corporation had no authority to issue the impugned communication dated 27/3/2023 based on the directions of the Lokayukt. Paragraph. For the aforementioned reasons,
The earlier order, last time, give representation, I have given representation.
we have said that it shall be at liberty. It is not a petition filed by you for in his petition. We cannot grant relief to you by directing. Nothing.
Time may be fixed, that may work.
It will be looked into by them. Same order.
Same.
Same order.
Same order.
28/12/2022 and this thing Lokayukt 28/12/2022 and Greater Warangal 31/3 allowed. Same order. Yes.
May I please?
Yes.
I beg to represent Sagarika.
Non-speaking. Mr. Rao. Yes, we know non-speaking order.
That's my kindly see, my lord. That's my kindly see the order passed by the University is page 15, lord.
Page
15, lord.
1. Hey, we thought that you will tell us that we will pass a fresh order.
I'll pass.
Right.
The same order I have to pass because the GO.
No. Speaking order. Grievance of senior counsel was confined to only non-speaking order. He will pass a fresh order.
I'll have to come back, my lords.
We don't know. So then we have to examine this then. give them. Because
I have to,
see,
well, I'm saying.
first, we are telling 1st of September, we only recorded this contention.
I'm aware of
So therefore, he saw time.
No, last time,
It has to be heard.
last
You are
time.
saying that you are right in saying that you will have to come back. But thing is that then in that case, he has to be granted the faculty to file counter.
Well, I'll tell you, Lordships, what's happening. I'm just taking liberty, my lords, because I see a few more matters happening. Unfortunately, today, what's happening, my lords, while the citizens' grievance is being microscopically examined, state action is getting a lot of laxity. This is unfortunate. After all, it's too late in the day for me to come and tell your lordships. 226 is for supervision of state action. What's happened, my lords, for example, in this matter, when your lordships passed it,
No, you are talking about the orders passed by this court.
generally,
Yeah.
not your lordships. I'd be too
Because that
unwise,
is, we can't,
to say that.
we can't do anything about it. You have the remedy under Article 136 if we pass such orders.
Unwise to say that. I'd be too unwise to say. All that I'm saying is this. Look,
Obviously, the only thing is what we are telling is last date of hearing in your presence, this order has been passed. That the only this thing is a non-speaking order. Probably that's why. But you are saying that if it is quashed, then on this ground you will have to come back again. You are justified in saying so. But only thing is, then we have to give them some breathing time to file counter. Because if we allow your writ petition today, the order won't stand because you will not be possible to. It will not be possible for you to defend.
36 is not any difficult.
No, defend it in saying that the court has not granted any opportunity to us to.
Only problem.
If you would have been for respondent, I think in Mr. Rao's position, you would have said that, sir, I need time to file counter.
I envy, my lords, but
No.
well, only sensitivity I'd like to bring on.
My friend, Lordsman, Lordsman kindly say the university, similar cases are coming and coming. University addressed a letter to the government seeking exemption of the rule for giving a notification. There is a rule what press registration after the cutoff date. Rule 126, Lordsman kindly say, page 126.
No, but you want to file counter or you want to, he is ready.
File my counter.
I right away.
My friend also there is no need to make an argument. The university addressed letter to the government seeking permission for giving a notification, calling applications.
Who is appearing for government? Nobody.
I believe the respond number 1.
What have you? He has written something we don't know. So yes, Mr.
Lords, I think this is a very sensitive input.
Yeah.
We now require a response from the government.
That's why we are granting them time.
Sleeping elephant that we
2 weeks time. Meanwhile, most probably notification will come. He may not apply. But even on the delay ground also it also be dismissed for the simple reason that the notification was issued on 3/8 ended with the 12/8.
No, they were in first round of litigation. They were here.
Yes, they were. In any event, they are now bound by your lordships earlier on.
36, no. Page 36, earlier round of litigation, he was there. Then 19/8 an order was passed, then he has come again. He doesn't want to come again now.
But
Right.
2 weeks time may be granted, I file my counter. They
Do
can
we have
counter
that much of time in hand? We don't have
1 week. 1 week.
Mr. Heard, Mr. L. Ravichandar, learned senior counsel for the petitioner with so and so. Mr. This thing, you also don't want to respond.
I am please respond number 1. I will ask to get in.
He submit that he doesn't want respondent number 1 accepts notice. Mr. Prabhakar Rao, 2 and 3, praise for and is granted a week's time to enable him to file counter. List on. One week, next Monday.
Next.
12 September 2023.
Sorry, my lords, if I had taken too many liberties.
No, we thought that probably you are saying in the context of orders passed by this court.
No.
Then
Not at all.
we can't help it, yes. You have a right to criticize, fairly criticize, but we can't help it sitting here.
It was not the intent.
Yes.
Item of the
Mr. Prabhakar, finally, what victims today?
Pursuant to my Lord's order on 17th of August, my lord,
Ah,
I have filed an affidavit, my lord, bringing to my Lord's notice the statement which I had made before my Lord's, my lord, I have filed it in form of affidavit to bring it to my Lord's notice, my lord, the action taken by the state. But in paying the
chart is there, madam.
earlier I had informed the court that
Rahul. Lockler, Rahul Reddy. Hey, madam, Rahul Reddy, Lockler. Call him. No, not here. Lockler. You are looking in the list. Mr. Yes, Prasad.
23 families were paid the ex gratia. Subsequently, not 24 more families have been paid. Ex gratia amount of 4 lakhs.
1 minute. So, Mr.
23rd August,
Mr. Prasad, what had happened? 1st August, we had issued certain directions.
Yes.
11th August and 17th of August.
17th of August, my lords were pleased to record my statement. I have requested my lord that I will place it in a place.
All right. Don't call.
I'll place it by way of an affidavit.
Not treated. Yes.
I have placed it by way of an affidavit bringing to my lord's notice 24 of
we will ask you one by one. You please answer. It will be very easy.
My lords.
Because what we have done is we have compiled the directions and your this thing and petitioner submission, right? That's what. So 1 minute. Mr. It is not an adversarial litigation, right? That's why we are asking. They are willing to comply, and we will ensure that they comply.
There have been complied many directions of this.
1 minute. So therefore, we have to pass an order. We have to handle the way this thing. No, who will write? You can this thing. So, first direction on 1st of August, Mr. Prasad, was number of deaths in Jaishankar, Bhupalpalli district.
Yes.
So, how many deaths?
There were 4 deaths, my lord. 4 deaths.
Five.
But 4 they could identify, my lord. 1 was missing. Subsequently, what has happened, my lord? Then the
1 minute. So, 1 is still missing.
Present affidavit, if your lordship sees, present affidavit filed on 20.
No, you tell us. We will not see anything.
I will.
You are here, Mr.
One is missing, my lord.
Very few cases we can take the liberty of not referring to record. And when senior advocates appear, we want that to happen. That we should not be. We rely on you. It's not again and again we are telling not an adversarial sort of litigation.
That's the reason.
So what? Bhupalpalli, this district, 5 deaths took place. 4 identified. 1 is still yet to be identified.
Yet to be identified is.
Mr. Who is this person standing there?
In the present affidavit, I have said so. Lady by Srimati Gattam Mahalakshmi of Jaishankar Bhupalpalli is missing due to the heavy flood. The search operation made with all such.
What her name is?
Gattam Mahalakshmi.
Missing.
Yes.
All right.
With regards to the
you will find out.
Yes.
You will carry on the efforts to find out.
With regards to one
minute. So total this thing, how many flood victims are there? You told us 41. Correct?
47 months. 40.
No, sorry, not flood victims. Total number of deaths. You told us 41.
Yes.
Correct, Mr.
Yes, 47 months.
47.
47.
Actually, I claimed 51, my lord. They are showing that 49. Out of that,
I'll explain.
1 minute.
I'll explain. 47. 23 I had informed my lords that 23
what is your figure? 47.
47
have lost their lives.
Yes.
Then out of you told us 23 identified benefit given.
24 also have been given. 24 also families are also
all given.
Yes, 47 have given. One more person, my lord.
All persons given the benefit.
Yes.
Correct.
This is the
position latest.
Yes.
Acha, then we had asked you how many cattles? 813, according to you. 813 cattle lost their life on account of floods. That's what you had told us, Mr. Prabhakar. 813.
Yes.
No, you are a stand, Mr. We have gone through it. Your stand is 813. And you will find it out, Mr. Prasad.
I'll find.
So then,
I've also informed the court.
yes.
One person who died, in addition to that, was paid Raitu Bima. Raitu Bima is insurance which was created by the state in favor of the persons who die during the floods.
So all persons insurance given? No.
Only one person was given, that is additional amount of 1 lakh given to a person. Addition to the benefit which is already given, ex gratia of 4 lakhs. Other aspect is with regard to the medical facilities which were made available to the persons who are affected, families affected, duly medicines have been also given to them. Medical facilities have also been given. But now, all the health relief camps,
1 minute. Flood victims, you have given medical relief.
Necessary food, stay and medical support.
Medical relief, food,
stay. And fresh water.
So how long they will continue to be?
I am informed through this authority, respondent number 5. There are no relief camps now being continued. No relief camps being continued.
No relief camps.
But what I would request.
So what you are trying to tell us that relief to all flood victims where when they needed,
yes,
it has been extended. They were made to stay in flood relief camps, and now nobody is there in flood relief camps.
192
they have returned to their homes.
Yes, 192 relief camps. 20,387 people affected by floods. 192 relief camps. 20,387 people were affected by the floods.
And they were staying in flood relief camps.
All of them
have gone back to their villages.
Back to their home.
Okay. Then, Acha, you have set up weather stations.
Yeah, weather stations. I've also given this.
Weather stations.
Yes.
Telangana State Development Planning Society to monitor weather data and hourly information to state data and to promptly take all precautionary steps.
Yes, bro. This is also done.
Done.
Yes. But
it is set up already.
It's set up. But if your lordships kindly see, if your lordship go to C, D, and E, C, D, and E, the same page, the Chief Secretary of the Head of State has conducted regular teleconferences during the period and video conferences with the district collectors, alerting them regarding the rains forecast and briefing them regarding the measures to be taken. Subsequent day to state has provided 10 NDRF teams deployed to helicopters in critical locations for the purpose of rescue and relocation. Thereafter, along with the IAF, Central Forces, NDRF, the local police and the state fire and emergency departments are deployed in vulnerable locations for rescue and relief. Holidays were also declared by the school to safeguard the. We have set up 192 camps for 20,387 victims. But I have also said so that Gaddam Mahalakshmi is missing, and the other person who was referred to by my friend is already been paid.
So we have taken note of the measures. Now, Mr. Prabhakar, what do you say?
Yes, my lord. Maximum they have been complied, my lord. Earlier,
what else is required to be done? You tell us.
Last occasion, this honorable court directed me to what else to be taken place.
That's what we are asking. What else should they should?
Shatakarkar stated in my reply, my lord, at page 7.
Forget no page 7. You tell us what do you want.
Yes, my lord. They need to prepare the plans, my lord, according to the Disaster Management Act. If they have been prepared,
what is section 39 of this thing, Disaster Management Act? Mr. Prasad, section 39.
Section 39.
Disaster Management Act.
Yes, section 30. Your lordship may kindly see.
My first of the affidavit, I had requested that the state would be taking all these measures, requesting time till 2024 March. But I had requested my first of the affidavits filed before my lords, appearing saying that everything will be put in place by March 2024.
To prevent the disaster, to manage the disaster and to provide the relief.
They have to do it.
Enacted the act, my lord.
We have agreed this.
Yes.
We have agreed to your submission
Yes,
that they need
and
to
the
take measure.
same were upheld by an apex court in Swaraj Abhiyan case.
They are not challenging
Yes, yes.
section 39. You are saying we will comply.
Yes.
It's time to be given that we will decide. I think, Mr. Not till March 24, that means April 24, you will tell us. You see, you take action and submit a compliance report, we'll say by December.
Fine.
Yes.
Fine. Deeply open.
And yes, what else, Mr.?
I have stated 8 suggestions before this honorable court for kind consideration of this honorable court to direct the government to protect the right to life of public at large and property of the public at large. It is 7 I have.
So, Mr. Prabhakar, what now the floods are not there in the state, right?
No, Lord.
1 minute, listen. Now, on a long time, our object is on a long time as a long-term measure. We have to ensure implementation of measures under 39.
Yes.
So what we will do is grant them some breathing time of 2.5 months and fix a date in the month of December before vacation and find out from them what section 39 measures have been taken.
Yes.
Correct?
Yes.
Mark the presence.
One more, my humble submission, finally, Millard. The project which is Kaleshwaram constructed under Godavari, Millard, 3 dams are there, Millard. Categorically stated in my reply at page 8, Millard, under 9 also, Millard. Those 3 dams, Millard, they are filling up the water. Once the flood would come, immediately they are releasing the water.
Which dam?
Kaleshwaram, Millard, at page 9, item number 5. Yes.
This is by way of yes, passed on the suggestions which he is making to the state, but to take appropriate measures.
What is the measure he wants to take?
I have put it across to the state. This is being too technical for me. I have put it across to the state.
Right. Measures to be taken, he has put it across.
Yes.
They need time to respond.
Yes.
We'll grant them. Next date we will, this thing, ask them what all have done. And about 39, about this dam.
Yes,
right.
And page 8, Millard, Himayat Sagar, Usman Sagar, which is existed a west side of the Hyderabad city, and they are not being properly implemented. GOMS number 111 of 1996, which was approved by an apex court, so that Hyderabad is being submerged in many areas, Millard. At page 8, I have categorically stated it, item number 3.
Completely a different issue, Millard, which is pending before this. Completely different.
But Mr. Prabhakar, earlier also we had told you we should take the issues which are interconnected. This petition will not be disposed of in December. We will take it up. First is commonality of issues. What flood relief is 39 and this dam, because it may cause floods again.
Yes.
So we will put them, give them some time. Of say 10 weeks and ask them to come up with this.
Deeply obliged.
I'm obliged.
Yes. Mark the presence, Mr. Prabhakar, Mr. Prasad. This quote, 1 minute. What is the order? 70. No, first one is in this petition, comma, one is Mark, the state had witnessed continuous heavy rainfall in and around Godavari river, causing floods in low-lying areas, which also resulted in breach of irrigation tanks, severe damages to agricultural crops and roads, and loss of how many lives? Loss of 37 lives.
May I start?
47 lives in the month of between. The rain was between when? Between
19th and
19th July to August 15th.
19 July to,
August 15th.
no, that was second, no.
19th and 20th, 19th and 20th of.
No, my lord, 19th July to August 5th, my lord, in my.
19 July till 27 July 2023.
Yes.
And thereafter in the month of August as well.
Yes.
August as paragraph. This court, a bench of this court had issued several directions to the state on 1/8/2023, 11/8/2023, and 17/8/2023. Full stop. In pursuance of the aforesaid interim orders, the compliance report has been filed on behalf of the state government. Full stop. The petitioners have also submitted their suggestions which may be implemented by the state government to ensure the safety of public in general in case any flood situation is caused in case any flood situation reoccurs due to heavy rains. So stop. Paragraph. We have heard learned counsel for the parties and have perused the record. Full stop. The from perusal of the perusal of various compliance report, it can be gathered that 192 flood relief camps were set up by the state government, in which 20,387 flood victims were granted the relief, granted the medical relief, and were provided food and fresh water. Full stop. Full stop. All the flood victims have now returned to their villages, and no flood relief camps note of and he doesn't need every time this court's direction.
Hopeless, deeply hopeless.
Mr. Other dam also, you find out what can be done.
Yes. In fact, I have forwarded made by request by the petitioner to the state. I'll come back with the report on December 18th.
See, on his own he is submitting. No step. Give one step. What a coincidence, right? You hope this has staple. He submitted section 39, Mr. Prabhakar, and then say Mr. Prabhakar fairly submitted that most of the directions issued by this court have been complied with by the respondents. However, he submits that section 39.
Yes.
Right? You put the pins. Yes.
Deeply hopeless.
That's how public interest litigation should be, right?
Yes.
A constructive sort of an
Yes.
approach.
I ever grateful to your lordships. I ever grateful to your lordships.
No, this thing. We are doing our duty. But this is what it is how public interest litigation should be argued, Mr. Prabhakar. That's what we are saying.
Yes.
We appreciate your suggestion also.
I'm deeply oppressed.
The otherwise adversarial sort of things.
Yes.
Every day we come across the encroachment on government land, people start arguing like as if it belongs to them. Yes. Okay. Yes, Mr. Advocate General.
My lord, sir. 19, item 19.
My
lord, the cause of the death is my lord.
19 and 20, in 20 you have to file counter. We shall take it up both the cases together.
Yes, my lord. Yes.
20 they should file counter, right? Already in 19 they have produced the reports, etc. But 20 is a petition by to constitute sit and take compensation of 50 lakhs.
So
you have please file a counter.
Yes, my lord.
Item number 20, Learned Advocate General, praise warrant is granted 4 weeks time to enable him to file counter. Petition is admitted for hearing, right? List along with 19.
Yes.
Yes.
May I please? The issue involved is about the legal issue, my lord. Synopsis, my lord.
Yes, we are ready. So, Mr. Now, no, correct. But we are asking you, now it says stand, right? That there is an arbitration clause. Remedy of a civil suit would be very tedious, right? You know how much time it will take and first appeal and then whatever happens, we don't know. So I'm just, before deciding this, we are putting it to you. So don't you think without contesting the case on merits, arbitration in the change scenario would be a better option for you? We will, if we ask you, if you want to really contest, we will enter into and decide. But don't you think that it's a better option now, and the change in stand has been necessitated on account of change in law?
The intention of the advertisement in the party is to consult the litigation.
Yes.
The outcome out of it.
Yes.
That we have taken up in 2016. In 2016, the advertised tribunal was concluded.
No, we can record his undertaking that he will cooperate and will not seek any unnecessary adjournment in the proceeding before arbitrator. Yes. But provided this is by way of a suggestion, then if you want to write it out, then we will have to decide. I think without contesting, it's a better option. That we record his undertaking also that he will not seek any unnecessary adjournment, will cooperate with the early decision of the proceeding. Arbitral tribunal should be constituted. He will give consent for this thing.
For such a conceding, I have to take instructions from my.
No, not but. So would you like to seek instruction or contest?
I'll take instruction, my lord. I mean, if your lordship kindly considers,
Where,
Because as on today, my lord, we are contesting it.
Ah.
Since your lordship has,
just think about it. It may like,
I paid, my lord, court fees, I paid the suits in the 2020, my lord, nearly 6 lakh rupees court fees are paid.
but it will be refunded, no? Now, you will withdraw, then it will be refunded now.
And one more thing,
The only thing is court doesn't give interest, that's all.
Milord, your lordship suggestion is, Milord, this variant, because within 1 year, even as per the act, also within 1 year, the act will be over. The suit,
No, but you will,
the suit will take years, Milord. In fact, it will be better.
Even now, the suits are pending before the commercial court, where, my lord, type is fixed up for disposal of the suits also. They are now pending before commercial court.
So you think, if you want to argue, we will go ahead.
Since your lordship made a suggestion, my lord, we have to consider, I have to seek my instructions of my client. I can't readily say much.
How much time?
Within 2 or 3 days, my lord, I can report back to your lordship.
6 is, we already have 102, that can't happen. 8th, we can take it up.
Sir, 8, 11, 8,
11th,
Monday.
Monday.
Next Monday, my lord, yes.
Monday 11th. Mark the presence. In this petition, comma, in this appeal filed under section 37 of the Arbitration and Conciliation Act, comma, petitioner has assailed the validity of the order dated 2/6/2023 passed by the commercial court, by which petition filed by the appellant under section 8 has been rejected. Paragraph. The parties had entered into a registered paragraph. Facts giving rise to filing of this appeal briefly stated are that the parties had entered into a registered development agreement cum general power of attorney on 23/3/2006 full stop clause 25 of the aforesaid registered development agreement cum power of attorney provides that the dispute between the parties have to be referred to a panel of 3 arbitrators. Out of the aforesaid 3 arbitrators, one each has to be appointed by one party, and the umpire is required to be appointed by remaining 2 arbitrators. Paragraph. The plaintiff invoked the arbitration, plaintiff stroke respondent invoked the arbitration clause, and a dispute was referred to a panel of 3 arbitrators. The full stop, in view of the then prevalent position, legal position as enunciated in so and so versus so and so 2005 within bracket 6 ALD, right? ALD
2015, madam.
15 6 ALD 584 comma 584 comma that dispute regarding cancellation of registered documents are not maintainable, comma, the plaintiff stroke respondent withdrew the arbitration proceeding and filed there full stop. Thereafter, the petitioner filed a suit for cancellation of this thing, DAGPA, whatever, DAGPA, full stop. The defendant number 1 thereupon filed an objection under section 11 within bracket under section 8 on the ground that the agreement executed between the parties, this whatever agreement executed between the parties dated 23/3/2016 contains an arbitration clause in view of later decision of Supreme Court in dash versus dash 2021 volume 4 SCC 786. Paragraph. Paragraph. The commercial court by an order dated so and so 2/6/2013
Interim order needs to be extended.
Interim order shall continue. Then say list on 12 September 21, 22, 23.
Public.
So previous my lord, this matter, also filed my lord and appellate, and grant 2 weeks time, my lord.
What? Vacate stay petition.
Yes, my lord. My vacate stay petition.
That's why senior counsel is smiling. So conveniently you are saying.
Earlier in this matter, my lord, additional sergeant appeared, my lord. Now the informed department.
You have filed vacate petition.
I filed.
You have filed. Okay. Then his petition, right?
Yes, sorry.
What do you say, senior counsel? 2 weeks for what we don't know. What happened? This thing proceedings are before under the act have been concluded. This thing final stage.
No, not concluded, my lord. They wanted to appoint a surveyor, my lord, to survey the property.
Interim order granted by this court says that you continue with the proceedings, but final order shall not be passed. That's why we are just trying to ascertain the reasonableness of the prayer for adjournment with reference to each stage of the
They
proceeding.
wanted to conduct the survey, my lord, till that it has not happened, my lord.
So we can grant them time.
2 weeks.
But argue on the next date of hearing. Senior counsel has today didn't say anything, but next day he will oppose, right? Mark the presence. This court by an interim order dated, a bench of this court by an interim order dated 14/7/2022 had directed that the proceeding under the Public Premises Eviction of Unauthorized Occupants Act 1971 may continue, but final order shall not be passed. Full stop. The respondents have filed an application seeking vacation of the interim order. However, learned counsel for the petitioner prays for adjournment to enable him to prepare the case and argue the same. List on 18th September 23 for consideration of IA so and so seeking vacation.
Deep low place.
So he wants to complete through interim orders of this court. Now comes the permission to attend classes.
The classes start.
That was granted, my lords. Classes are big.
So what IA you have now? It has
IA 2 is also been allowed.
Yes,
So
it has
what
been
is
allowed.
1 of 23? No orders necessary to be passed on 1 of 23.
1 of 23.
What is 1 of 23?
No orders are necessary. To appear for the examination, that has also done.
All right.
He's also attending.
He's the petitioner, right?
Yes.
Advise him to attend classes.
Yes.
And not to spend time here in the courts.
The classes haven't begun, my lord. Like I asked him even today.
Advise him to be in the library, read all the classic case laws of. I think you will inspire him to do something better than not attending classes and this thing.
Definitely. In fact, I've been literally parenting him on that.
Yeah.
Telling him you have better go back to college. Yes, starting next week.
Mark the presence. Learned senior counsel submits that IA 1 of 23 has already been allowed. Therefore, no orders are required to be passed on IA 1 of 23.
Right.
What amendment?
To represent. Lords have filed amendment petition.
Yes, what do you think, Mr.
My lord,
Can we allow amendment?
Minute can be closed, my lord, because the repetition can be closed, my lord. The section 243, the last occasion, my lord, please wait to get instructions. The 243 repeal of certain enactments of savings. Now, my lord, this repealing is not yet notified. But you can avail the remedy under 243, my lord, and after
Why he can avail of the remedy?
No, personal insolvency.
Madam, IA, my notes, please give. I can't see. Yes. say, the grievance is that section 94 is not notified the IBC.
Yes, yes.
So he cannot get a declaration that I am insolvent. This is number one.
Yes.
Secondly, he says that he had filed a petition under Provincial Insolvency Act. It was rejected by an order dated 8/12/21.
Yes.
So he is remediless and therefore under Article 226 an interim order.
Therefore, the repeal, section, the very itself, it is not notified. Therefore, it can avail in a act.
No. But the problem is, Mr. Praveen Kumar, is he had filed the petition under provincial insolvency.
Yes.
It has been rejected by an order dated 8/12/21. Where is it, Mr. 8?
Page 41, my lords.
41.
Need copies at page 41A.
8/12/21, right?
Yes, my lords.
Page
41A.
41A.
Yes, my lords. 41 is the title.
Returned for. Who has returned?
The small causes court section, my lords, on the ground that how IP is maintainable under.
Page 26, main case.
We will, Mr. Order, we'll set aside this order.
One submission, my lords. I have prepared the notes. One submission I will make.
No. Mr. We are granting relief and you are making
Yes,
some.
yes, my lords.
This order we will set aside and ask the this thing small causes court to try your petition
Yes,
on
sir.
merits.
Yes.
There are two learned single judge judgment of this honorable court. If your lordship so says, my lords, I will pass on that. Because that has to go.
Watching. What orders, single judge?
I may be permitted to pass on, my lords. I have prepared small notes also if your lordship so pleases, my lords.
Oh, nice. No, but what, why it has been written, why, what has been held?
They say that under section 8, because section 8 of the Provisional Insolvency Act bars petition against banks, companies and corporations. That is the view of some other high courts also, my lord. But Kerala High Court, my lords, has said no, section 8 doesn't bar it because, my lordship, if your lordship sees section 8, there is ambiguity in the main provision.
Mr. He doesn't want closure of the petition. He wants to continue perpetuity because interim order is granted. He wants it should come up after 25 years. By that time, petitioner would have left the world. He will be designated senior counsel. Lighter when we are saying, Mr. Don't take everything seriously, right?
I cannot take.
Cannot take. Good, not to take things serious. So, what is the reasoning of the decision of single benches you are saying?
My lord, they,
Of our court, what is the reasoning?
Yes,
Which page?
Page number, my lords, of this honorable court.
You have High Court of Allahabad, you have.
Yes,
I
but
think
different high courts. Page number 10 is our high court. Page number 13 is our high court.
10. So, it should be annexed in the compilation first, right? Allahabad judgment, nothing, single bench.
Yes, my lords.
What is it?
Page number 10, my lords.
1 minute, one. So, you have filed against whom?
My lords.
You have filed the petition against whom?
Against the banks.
Then section 8 prohibits filing of such a petition against bank.
It is what the learned single judge say, my lord.
No, what does section 8 say?
Against corporations, association or company registered under any enactment.
So it's not either of these. Bank is a separate entity.
One submission. Company registered under any law, banks, all banks under Banking Regulation Act of 1949 come under the company registered under any law.
So you are saying that no remedy.
Yes, that is what page number 13, my lords, another single judge of this honorable court has categorically in point of the banks have said. Page number 13, para level.
Case of bank.
Case of banking, page number
So
30.
then this should have been the first decision in your compilation.
I'm sorry, my lords.
This applies directly to your case, right?
Yes, my lords.
It should be first in compilation. Page 11. Yes, Mr. It requires consideration. Madam. We'll admit it.
Yes, my lords.
You are already surviving on an interim order, right? Be happy.
Yes.
It's for admission.
Yes, my lords.
Heard on the question of admission. Good effort put in.
Obliged, my lords.
So that's how you should do it. Where is that this thing?
I have given notes.
Note? We don't have any note. Synopsis.
Yes, my lords.
Good. Keep it up, Miss Young Man. Yes. The petitioner heard on the question of admission. The petitioner had availed of loan from respondents 4 to 17 to the tune of rupees 3.25 crores. Full stop. It is the case of the petitioner that on account of circumstances beyond his control, amendment allowed.
Yes, ma'am.
Heard on beginning right. Heard on IA 2 of 23, taking into account the nature of proposed amendment, same is allowed. Let amended petition be filed within
We have filed, my lords. After filing only number comes.
All right. Hello.
Oblige, my lords.
Petition is admitted for hearing, counter if any be filed within 6 weeks. Next.
Your Lordship, item 28 and 29, Your Lordship, are questioning the GOM.
Admitted for hearing. 6 weeks time is
Batch is pending.
6 weeks.
Batch is pending, Your Lordship.
6 weeks time is for granted to file counter list along with WP number.
350,507.
WP
WP 33507 and 2022. This batch is there.
Madam, right? Yes. Yes. Yes.
What's your best?
32, madam, 54. 32, 54. Yes. They counter is not filed.
Counter is not filed by the state, madam. State has to file the counter because rule is.
Petition is admitted for hearing.
In this case,
Let counter if any.
in this case, in one of the case, I filed the counter. In all cases, is similarly situated, where
Memo has to be filed or copy has to be given. Which case you have filed counter? Mr. Item number 32.
54, madam.
54.
All cases.
Which case? 1 minute. Which case you have filed counter?
In Aravindo Pharma, I filed,
No, we don't know Arvindo Pharma number. Serial number.
Item 34. 34, madam.
34.
Malad, in WP 22739 of 22, I filed the counter.
My madam.
No, this is not WP27. Which case?
32, Malad, item 32.
Municipality, others.
22739.
Yes, Malad. This is related to Aravindo Pharma.
Municipality seems to have filed counter, madam. This matter, not the government.
He is government, right?
Administration I filed.
Very good.
Because municipal administration.
State counter, they can pass on to all the other cases also.
Item 30 to 54, madam.
We have included in documents for us. Those documents are not shown on only the copy of the copies. Refer to certain circulars.
Speak into the mic so that your friend can hear. He has not heard.
Certain circulars which have been referred in the counter, my lords, those were not served upon me. Only the counter
Item
copies.
30 to 54. You are government advocate. What? Government pleader.
I will file counter. I will GP for municipal administration.
GP for municipal administration submits that he has filed counter in WP number 22739 bar 2022. Learned on the learned counsel for the petitioner submits that learned counsel for petitioner in WP number 22739 bar 2022 submits that he has not received the copy of annexures. Copy of documents annexed with the counter. Paragraph in view of aforesaid submission, learned GP undertakes to supply a copy to Mr. Counsel for petitioner in WP number aforesaid rate petition, right? the land held by the petitioner Say, 1 minute. His submission, learned senior counsel for the petitioner. Just now. It is further submitted, one line. It is further submitted that claim of the petitioners except the petitioners to whom the compensation has already been paid be examined within a fixed time limit by the competent authority. Yes. They will not go, Mr. They, on the other hand, then what he submitted shall be examined. Examined. Such of the petitioners grievance, madam, read what is his submission. No, you don't, claims of the petitioners, claim of such petitioners to whom the benefit of compensation, delete everything, to whom the benefit of compensation has not been extended, shall be examined by the RDO Siddipet within a period of 2 months from today, and the amount due to them shall be paid to them. Paragraph. We have considered the rival submissions made on both sides. Para 8 of the will find out. If we don't find out, then you are just getting, give it. Other, we have 340, we have other memo you do. Read as in the quote. Paragraph. In view of the, no, not this memos. Therefore, it is, therefore, in view of the consensus, right, in view of consensus arrived at between the parties, and in view of the fact that the petitioners have confined their grievance to paras 8 of the memo, dated 4/7/2023, filed in all the 3 writ petitions, it is directed that the Revenue Development Officer Siddipet shall consider the claims of the petitioners, within a period of 2 months from today by a speaking order. Needless to state that the
Right. That's good.
Oh, lunch motion. We have given a dictation in the morning. Who has taken in item number 4? Whether she has typed, give the order. Lunch motion.
Your lordship's common order is there.
Common order?
Your lordship's order pertaining to CCAT.
29th August. Which common order?
Yes, ma'am. Yes, ma'am.
Not 29th August.
No.
Representation.
Consider the
Consider representation for registration of under B and C category.
You are ready to consider or what?
Lordship kindly see, he did not register himself. Pursuant to notification issued by the university.
Why you did not register?
My lord, in this first case, there was a technical error. B category has been registered, my lord.
No.
So for a C category,
What was the last date of registration?
But it starts from 3/8 to 12/8 lordships.
3/8 to 12/8.
lordship.
Same case like
Yes.
One lady advocate was arguing in the first half.
Yes.
We have disposed it of or what?
Directing the university to consider the representation.
That's what we can do. Is there a similar order? Not.
29th, your lordship will find the order at additional documents I filed, page 12, my lords. There is another affidavit, additional documents.
Yes, sir. Yes, Mr. Rao, what do you say? 12? Huh?
Page 14. Yes, sir.
14.
Same order.
Yes, madam.
3 matters.
1 minute. Page 14, same order, right? Consider and decide. Page 14, certified copy today.
Gotcha. Next 2 matters.
One, two,
2 and 3 also same.
same.
Oblige.
I beg to appear on behalf of Advocate Thomas George Lordship. I beg to appear on behalf of Advocate Thomas George Lordship in this matter. Lordship, this writ has been filed to consider the petitioner, the NEET counselling which is scheduled to happen in 4 to 5 weeks, Your Lordship.
NEET counseling, admission to which course?
To the MBBS course, Your Lordship. The petitioner is a meritorious candidate and is a non-local student who has studied his entire education in the state of Maharashtra. And he could not register for the counseling for the state of Telangana, Your Lordship. We are only requesting for, he's a meritorious candidate, Your Lordship.
We don't know.
Yes, Your Lord.
Whether you are meritorious or not, that is considered by Mr. Rao. We don't decide it.
We are only requesting.
This thing, we can't, I mean.
It is to register and participate.
We can consider, you can, what is the reason why you did not register between 3/8/23 to 12/8/23?
No, competent authority. Competent authority is seeking.
3/2, that rule which is challenged.
Yes.
No, not challenged.
No, Lordship kindly see.
What sort of relief they pray, difficult to get, Mr. Rao. Please read page 11. Permit the register online provisional merit list. Permit participate in the counseling B category non-local candidate. So what was the last date of registration for
B category? We got the 12/8.
12/8.
No, he is not even a local candidate. He is
So
We are asking for
one minute. What did you do from 3/8 to 12/8?
Your Lordship,
taking chances in Maharashtra, then found out that you are not granted admission, then you are coming here.
My submission, Your Lordship, is
It's not that.
Your Lordship, here is
Mister, there has to be a valid justification so that we can direct them to consider your grievance. Why you did not participate between 3/8 to 12/8?
Your Lordship, in this matter, previously the norms of non-local relaxed by this Honorable High Court in the month of August, wherein sitting 4 years, if you studied outside the state.
So you are a fence sitter, right? Waiting for the outcome of
No, Your Lordship.
So that
We
item
were-
number 4 order.
That's right. Your Lordship,
Delay. We are today, Mister, we have passed an order declining the relief to a petitioner who has approached, but
they won't send a brief.
1 minute. But you have not this thing claiming admission as local candidate.
We are claiming as non-local only, Your Lordship. We are saying under category B only.
Sir, that
we are not claiming as local. We are not claiming as local. We are claiming only under the non-local category.
It means you have not read the judgment division rendered by division bench of this court. That's why that judgment deals with local candidates. The rule 33B, if you don't know, and we are not under an obligation to tell you, but still we are telling you, rule 33B of 2017 rules has been read down, and instead of striking down, it has been read down, and it has been said that it does not apply to local candidates of permanent residents of state of Telangana. That judgment, you are not a permanent resident of state of Telangana.
We are holding.
So therefore, division bench, that senior person is correctly advising you to listen to the court, because what we write matters. What you speak doesn't like. Ultimately, we will have final word, right? So you should understand the query of the court. That's why he is guiding you by being patient. Being patient is a big virtue in this profession. We are patient all the time, but we have to pass an order. So we are putting you query because your prayer clause doesn't make any sense, right?
Your Lordship, may I make
1 minute. Everything is time bound. Admission. University had notified that you can register your application from 3/8 to 12/8. Why you did not do it and filed a petition on 2nd September 23?
The only reason, Your Lordship, is
you are from state of Maharashtra.
No, Your Lordship, we had found the. We are not for you.
Mr. Still, even assuming that you are a permanent resident of state of Maharashtra and entitled to apply under non-local category, understood, right? It's not that difficult. But still you are required to tell us that between 3/8 and 12/8, what were you doing? And from 12/8 till 4th September, what you have been doing?
I shall mention the same, Your Lordship. Between the month of July and August, the counselings, the state of Maharashtra was ongoing, and the first round and second round completed. And in the second round of counselling, the petitioners secured one seat in a college, Your Lordship. Thereafter, in the month of August, our Honorable High Court was pleased to read down the rules for non-local state.
No, there you are wrong, Mr. That means repeatedly, second time we are telling you, despite being told, you don't seem to understand. Firstly, you have not read the division bench judgment which we have delivered. And we just now, 1 minute ago, we have told you what is the ratio of that judgment. Still you are saying non-local candidate. That doesn't deal with non-local candidates. It deals with the candidates of permanent residents of state of Telangana.
Yes, Your Lord.
You are not a permanent resident of state of Telangana. You are arguing that I am a permanent resident of state of Maharashtra and therefore a non-local candidate. Even assuming you are non-local candidate, what were you doing from 3rd August till, and we can't grant you this relief?
Your Lordship.
Delay.
Your Lordship, now only the petitioner got the opportunity.
Read the now prayer clause. You could have got an opportunity in the month of December. So can we say direct them to admit you in register in month of December? You understand, right?
Yes,
it's all a time bound thing. And they have fixed a schedule. Why R.D. Shetty Supreme Court denied the relief despite laying down the law? Because petition was filed with delay and latches of 8 months. Same thing. Firstly, you are not entitled to benefit of division bench judgment. In a similarly situated cases like local candidates, we have rejected the petition today by saying that the discretion of this court under Article 226 will not be exercised in favor of a person who sleeps over his rights. In case you wanted to participate in the counselling for the state of Telangana, you had to adhere to the time schedule prescribed by them. The time schedule for every candidate alike was 3rd August 23 to 12 August 23. You can't have any reason to say that I will not be governed by calendar of events notified by them and I will come to the High Court and whatever, do whatever feel like.
No, Your Lordship, my submission on the division bench judgment is, Your Lordship, yes, it is applicable to the locals who are permanent residents of Telangana. I am only on the point that because the judgment makes it applicable to the permanent residents of Telangana who have, however, studied for 4 years proceeding to this course outside the state of Telangana, they are also considered local if they have studied residents of Telangana. Now, because of that, the number of people competing in the
No. Again, Mr. Have you read it?
Your Lordship,
Ask yourself the question, have you read the judgment? Not read it.
this court had read down the.
No. Have you read our judgment? We are asking you a straight question.
I have read, Your Lordship, and in my
Then your
limited
impression-
understanding.
The impression is wrong, Mr. Counsel. Impression is wrong. We have not held anybody to be permanent resident. Competent authority of the state government, that is Tehsildar, decides who is a permanent resident. We do not decide questions of fact under Article 226. We cannot decide who is a permanent resident. Therefore, we have relief, we have confined. What? I mean, we are sitting here to convince you, right?
No, Your
Sorry.
Lordship. My
You argue your own case. You have not answered the question 3.8 to 12.8. What were you doing?
Your Lordship, the whole crux in the matter here is.
The crux is page 11. Read the prayer clause.
To permit the petitioner to register for counseling of MBBS admissions.
Why?
We have
What
seen-
ground permit?
Your Lordship, we have even sent.
No. Why? You tell us that if the time limit is over on 12/8/23, how should we permit you to on 5th September to register?
We could not have the chance then, Your Lordship, because of that, Your Lordship. We are only
Next
seeking-
year. Chance have next year. Participate in Maharashtra and Telangana next year. Mr. Rao will have different set of rules next year. He will be
Your Lordship, we even
defending different set of rules.
Your Lordship-
Mr. Rao, today, this year being the last year, no?
Yes, sir.
So next year you will have different set of rules.
Yes.
We are asking him to be more vigilant next year. Participate in Telangana and Andhra both, and Maharashtra also.
We
already got admission in Maharashtra. If your Lordship permit me, I may make a small.
Yes, please.
My humble submission is, my Lord, when this rule has been read down, a few people who are treated as non-local will become local by virtue of the judge, Tahsildar's permanent residency certificate. Then there are all possibilities for getting a non-local
Vacancy. So what happens to the last date? If you would have registered.
At that point of time, I don't fit into that.
So if you would have registered on 12/8, we could have considered this argument that if they are treated as locals, you are perfectly justified. Then this seat will fall, it may fall vacant and by a 42 circumstance.
Your Lordship, it's perfectly, that is correct. My humble submission is, at that point of time, I don't stand a chance to apply even, because I don't have opportunity of being a non-local to get into that slot. Now, by virtue of this migration, there is a scope that this applicant stand to get a chance to this non-local quota.
No, Mr. Counsel, today we have passed an order, we want to apprise you. Therefore, thereafter you argue whatever. Today, a similarly situated candidate like the one in the batch which we decided on 29th August, they came before this court on today and saying that extend us the benefit of that judgment 29.8. We have declined, saying that in discretionary jurisdiction under Article 226, relief cannot be granted to a fence sitter.
I really appreciate that point. My only
we have referred to 4 Supreme Court decisions that may be wrong, right, whatever, but we are sure that it will be tested in a forum competent to deal with it. So we will eventually abide by it. But as on today, no justification is forthcoming in the readout from the petition that we have got it, that 12/8/23 How could you anticipate that we are going to deliver a judgment on 29/8, therefore I will not apply?
It's not that perfectly, I mean, my humble submission is, at that point of time, I'm not eligible in any means to get
Why?
these.
Not local, no, Mister. At that point of time also, today also you are claiming a non-local candidate. That time also you are a non-local candidate. You could have applied between 3/8 to 12/8. Had you applied and sought for a relief now, we would have appreciated this point.
My humble
This is,
submission.
you can't rely on a 42 circumstance. What is going to happen? We don't know. Mr. Rao may have challenged that order, our order in Supreme Court. What will happen? We don't know. Then again, you will file a petition that now my chance has come because order has been set aside by Supreme Court. Therefore, I am entitled. This can't go on.
Your Lordship, I'm very sorry to.
This thing, no, not sorry. Mr. Why we are vocal? Because we believe in giving a fair chance to the council to understand. Otherwise, we will hear him quietly and dictate the order. We are being fair to both of you by disclosing our mind what is going on.
I got it. My only humble submission is to make the ends of justice to a meritorious candidate.
Ends of justice, Article 142. Article 1. We don't have that power. And apart from Article lighter vein, 1 minute, listen. Apart from Article 142, lighter vein, Mr. Prabhakar Rao alone has that power to admit you even today or tomorrow. We can't do this thing. You approach him, convince.
I make a humble submission, my lord.
Yes.
I have sent a mail to them seeking, that is an exhibit in this.
That they can look into. But the prayer is for consideration. Prayer is to register, permit to register. Prayer is if you
Consider the mail.
consider the mail.
Yes.
That can be done.
Fair enough.
Mr. Rao, consider their mail. Correct? Yes, Mr. So shall we?
Mail date, it's on page number 26, my lord.
Mail dated?
Dated 1st September, Friday.
Right?
Page number.
Shall we dispose of then?
Yes, ma'am. With this instruction, I'll try my luck.
Yes, better. Mr. Rao is a very magnanimous person, right? He may consider, we don't know. Mark the presence with consent of the parties, matter is heard finally. In this petition, the petitioner inter alia seeks a direction to so and so university, Kaloji Narayan Rao University of Health Sciences, Warangal, to permit the petitioner to register for counseling of MBBS admissions for the academics. If this sentence further submitted, right? Learned counsel for the petitioner fairly submits that he does not the petitioner does not.
Applies for this patient hearing, your lordship.
May I please?
What to do? Treatment. I want to
Get on. Fine.
Yes.
May I please? As the appeal is arising out of Millet's Land Acquisition Act, Millet's. I have prepared a brief dates and events, Millet's.
Very good. Brief dates. What has learned single judge done?
Millet's claiming parity, Millet's of GO 678. As the land of the petitioners was acquired, Millet's after following due procedure. Millet's an award was passed on 1/2/2000. And Millet's, since there was a title dispute between the endowments department and the writ petitioner, dispute was referred under section 30 and 31 to competent civil court by LAOP number 20. That's claiming parity that they have allotted alternative land in favor of one Lieutenant Colonel D.N. Sharma and his son. The petitioner requested for allotment of alternative land in view of the acquisition. Then the court fined for
claiming parity in treatment.
Yes, Mallards.
So why you should not treat your citizens alike?
No, Mallards, ultimately the writ was allowed. The relevant single judge find fault with the manner in which the issue was dealt with, and ultimately at page 36, Mallards, these are the directions. Writ was allowed. Imposing cost of rupees 25,000 Mallards on the other writ.
Must be allowed.
It's 36. I will come to Mallards the next
33.
aspect.
33.
36 Mallards.
Here it's 33. 30. 36 is.
That's 8th line, Mallards.
1 minute. Internal page 33, right?
34 Mallards.
No, the result. Heading is the result.
Yes, the result Mallards at page 33 Mallards. For the aforesaid reasons,
The writ petition must be allowed. It is accordingly allowed. The first respondent is directed to consider allotment of alternative land to the petitioner in an extent of 914 square yards or any other appropriate extent of value equivalent to the value of the petitioner's land acquired. The value of the land to be allotted must be computed as on the date of acquisition notification of the land of the petition. This is how the state computed the value of the alternate land allotted to the Sharmas, and this is how the valuation of the land to be allotted to the petitioner must also be considered. Since all the proceedings under the Act were taken on the premise that the petitioner was the owner of the acquired land, the alternative land should first be allotted in his favor, but subject to the eventual claim of the endowment. State must, this is important. The state, Lakshmi may kindly have note this aspect, Manas. The state must do the needful for expeditiously determining the endowment's claim if there be one is still pending. In case it is eventually determined that the petitioner is not entitled to this land, but the endowment is, the alternative land shall stand allotted to the endowments for its benefit. My respective submission is the dispute while the disposal of this writ petition, Malas, already on 1/2/2000 dispute has been referred to Malas competent civil court under 30. As there is a subsequent development Malas on 26/9/2018. Malas LAOP was Malas disposed of, wherein Malas it was held that Malas the writ petition is not entitled for any compensation. May I pass on those two orders, Malas? In view of this, Malas, the claim of the writ petitioner was rejected by the reference court. And that was not challenged.
Your Lordship, one alternative land was allotted in favor of Sarma. Is the land
No, what happened to LOP order? Reference
not
to.
aware, Your Lordship?
You say that not aware, give him copy.
Yes, I'll supply my.
And one more thing, Your Lordship, in this Sarma was allotted the land that is the land.
Your entitlement will, have you filed an appeal against this order?
They have not filed it.
You are not aware, Your Lordship, you are not issued any.
Paragraph 23 onwards are the findings. The ultimate finding is at page 20, paragraph 25 minutes. This court, in view of the aforesaid analysis, holds that the claimant number 12, that is the writ petition minutes, is not entitled to claim the compensation amount for the acquisition of 914 square yards of land by the land acquisition officer, as PW1 has failed to establish the lawful and legal title of his father or his lawful title by way of any registered document in respect of the said land.
Your Lordship, I will verify with my client and submit. But in fact, Your Lordship, you are not aware with regard to this. And Your Lordship, one more submission is the Sarma was allotted alternate land. His case also referred to the section 30, Your Lordship.
No, so in his case also it was held he is not entitled. Huh? And despite that land has been allotted. Is it your case, mister? Not that. You don't know.
No.
Please understand.
Lordship, kindly consider one.
Whatever Mr. Sharma was allotted, it has been implemented. You are claiming parity. He is saying that in your reference, it has been held that you are not entitled to claim compensation and you have not filed an appeal. So do you want to say that in Mr. Sharma's case also reference court held that he has no title despite that they have given him? Not your case.
That is not our case.
And the case set up by the writ petition is basing on an agreement of sale.
Your Lordship, and they have given undertaking.
No. The question of discrimination doesn't arise because you don't have a title. Mr. Sharma had title.
Your Lordship, only question is whether I am entitled for alternative land or not, Your Lordship. That this
You are not entitled in view of this order passed by the reference court.
Monday, Your Lordship, I will get it. So that
I leave it.
What Monday? 3 days you cannot find out.
And Mallet,
3 days you cannot find out. Your client stays in South Pole or where? Somewhere. North Pole.
That's right, Dr. Lord.
In Hyderabad only, right?
Not only, but
whatever. Then find out.
Contact the Lordship.
He will find out. You don't have to.
Your Lordship will try to
mark the presence.
Contact your Lordship. Not in a position to contact.
No, that's why.
Monday, Your Lordship will.
No. We'll fix it on this thing. Yes, madam. Right. This inter-court appeal has been filed against order dated 23/11/2006 passed in the writ petition by learned single judge. Paragraph facts giving rise to filing of this appeal in nutshell are that the land belonging to the petitioner measuring 914 square yards situated at Somgam, Langer House,
That was
the
ultimately
petitioner filed a writ paragraph. The respondent filed a writ petition, namely WP number 7551/1998, challenging the notifications issued under Section 4(1) and Section 6(1) of the Act. In the said writ petition, an interim order was granted on 12/1/1998, which was made absolute on 9/11/1999. Paragraph. During the pendency of the said writ petition, the respondent made an application seeking allotment of an alternative land. Thereafter, during the pendency of the petition, correct? Right. The
one date is missing, 1/2/2000. What has been passed, my lords, and it was referred to civil court.
Delete, madam.
On 1/2/2000.
1/2/2000. On 1/2/2000,
Yes.
an award was passed
And
to stop the petitioner being dissatisfied with the quantum of compensation.
Not the petitioner, there was a title dispute. There was a claim by endowment.
Right.
So the land acquisition officer referred the dispute.
Delete. The award was passed on so and so. Since there was a dispute with regard to title in respect of land in question, the dispute was referred under Section
30 and 31.
30 of the Land Acquisition Act
by LAP number 20.
For adjudication before the civil court. Paragraph. The petitioner filed a writ petition in which memo dated 25/1/2023 was challenged, by which his claim for allotment of an alternate land was rejected. Full stop. The learned single judge, by an order dated so and so.
But your lordship, that rejection
One
was
minute.
challenged. Your lordship, okay. That rejection was challenged in the writ appeal, your lordship, that was set aside and matter was remanded. This is the, they have
One
filed
minute.
that.
Don't interfere. Don't interfere when the order is being passed. Filed a writ petition. Right? The petition was dismissed.
Writ petition was dismissed against her to carry the matter.
The writ petition filed by the respondent was dismissed, against which he filed a writ appeal in which the he filed the writ appeal. Full stop. A division bench of this court remitted the matter for reconsideration. The learned single judge thereupon, by an order dated 23rd of November 2006, has allowed the writ petition and has directed the appellants to allot an alternative land. Full stop. In the
Subject
opposite
to adjudication of dispute.
subject to adjudication of the dispute pertaining to title. Paragraph. Which was pending before, which was pending before the reference court. Paragraph. When the matter was called today, learned so and so GP for revenue.
Attached to advocate general.
Whatever. Has produced a copy of judgment dated 26 September 2018, passed in LAOP number 20/2020, by which the question of title has been adjudicated, and it has been held that the respondent stroke landowner has no title in respect of the land in question. It is therefore contended that it is also pointed out that the petitioner has that the respondent stroke landowner has not filed any appeal against the order dated 26 September 2018. It is therefore contended that the petitioner is not a respondent landowner is not entitled to allotment of any land. Paragraph in view of aforesaid submission, learned counsel for respondent prays for adjournment to enable him to seek instructions and to make a statement whether the order dated 26 September 2018 passed by reference court in LAOP number 20/2000 has been challenged by him in an appeal. And if so, what is the status of the appeal? List on Monday, 11 September 23.
Pleasure.
There is nothing actually we could have disposed of. He obviously has lost. That's why he is not contacting the respondent. He will find out Monday. He will tell us that. See, you only tell us whether you have filed an appeal or not. Then you agree that if you have not filed an appeal, it goes nothing.
Even if they prefer an appeal, that would be subject to the result of that appeal. Even if they prefer.
No, but you are saying that it has not filed. They have not filed.
They have not filed.
Let's
only the endowments have filed. Both the claims were rejected.
Let's see.
Pleasure.
See. Application failing which? Yes, none for the. We are not asking you who is appearing for respondent. None for the appellant. Despite write his name for respondent, despite opportunity being granted on 28/8/2023, to make an application seeking substitution of LRs of diseased appellant, no application seeking substitution.
Interim order passed on 21st May 2008. Directing the interim directions till the disposal of the writ petition. Writ petition is pending before the single bench.
Single bench?
Against the
The list survives.
Against the interim
Yes,
of the
madam.
order.
So we have to hear.
And in fact, you lords may close the writ appeal and direct the writ petition to be taken up for hearing. That would. Because the interim order is till the.
No, what happens to WP 2180?
Your lordship still not constituted, your lordship.
180 because of the interim directions granted in this division bench order, unless my petition is decided, but they would not get the relief. So both have to be tagged on before the single bench.
Writ petition number 13618 of 2022, your lordship.
Item gives 64 item.
This is a connected matter which a senior counsel is saying.
Correct, right? He's making a correct submission, right?
Yes, your lordship, the fixing of the rotation of the board of trustees, your lordship, year by year.
No, not rotation.
Interim order date
What he said?
21st May 20.
2008. Are you aware, madam? 21st May.
Lordship, another writ petition has been filed by the learned senior counsel, lordship. Writ petition number 313.
She has not understood what you have said. She has been fed into that adjournment has to be sought and something says. Did you understand what he said, madam?
Yes, your lordship.
What did you get?
Senior counsel said that the other writ.
No, senior. What did he say?
You said that other writ petition,
What is the interim stay as prayed for means? Which writ petition, Mr.?
That is 7040.
it is not been.
7040
of 2008.
8. So it comes before this bench or any
Before
other
the single bench.
single bench.
Against the interlock the order, writ appeal.
We request the learned single judge to decide this WP 7040/2008, madam.
Along with their writ petition.
Lordship,
It's a writ petition, but their writ petition is before this division bench.
Lordship,
Because of the writ appeal, money it was staggered on to the.
Okay.
Lordship,
Will you explain it to her, Mr. Counsel? Explain.
Lordship's kind permission.
1 minute, we will hear you. Please understand what is. This writ appeal was filed against an interim order. Interim order passed in WP 7040. Which is the interim order WP 7040?
Interim order is dated 20th March 2008. Sorry, I'll just.
20th March.
1st April 2008. In WPMP 9218 of 2008.
All right. This interim order has been stayed by division bench. And the writ appeal is, writ petition is pending.
Your Lordship, another writ petition also pending before the
But we decide
same matter, Your Lordship, pertaining.
you can file an application for linking. We will send it, madam, to single judge. You understand, right?
Yes, Your Lordship.
Correct. That's it. Yes, that's what we wanted. Yes, write down. In WA. WA 528/2008. The this intra-court appeal filed under clause 15 of latest patent arises from an interim order dated 1/4/2008 passed by learned single judge in WP number 7040/2008. Paragraph. A division bench of this court, while entertaining the writ appeal, while admitting the writ appeal by an interim order dated 21/5/2008, had granted the stay of the order passed by the learned single judge on 1/4/2008. 1st May 2008. Full stop. 1st May 2008. Full stop. The aforesaid interim order is in operation till today. Paragraph. Therefore, full stop. Forcing till today. Full stop. It is not in the, it is paragraph. Admittedly, the admittedly writ petition number 7040/2008 is pending before the learned single judge. Full stop. Therefore, in the facts and circumstances of the case, we direct that the interim order dated 21/5/2008 granted by a division bench of this court in this writ appeal shall continue during the pendency of WP number 7040/2008. Full stop. The writ appeal. Full stop. The dispute in this appeal pertains to non-constitution.
Executive board, trust board of the temple.
For constitution of the, with regard to constitution of the trust board of the temple. Full stop. The writ petition is pending since 12 and 15 years. Therefore, we request the learned single judge to deal with WP number 7040/2008 expeditiously. Line below, accordingly, the writ appeal is disposed of. Paragraph. Other case, madam. Other case. This is WP 2180/2007 in view of order passed by us today in WA number 528/2008, let this writ petition be listed along with WP number. Next. Uh, 65 to 73.
Serial number 73.
The virus of section 22A.
I am
22A of registration.
Item number.
Virus of 22A.
Yes, madam.
Registration Act.
The matter is remanded by the Honorable Supreme Court. My lord, this matter may not take much time, my lord, so if the lawyers confined to the core issues, my lord, then I will reply after their submissions, perhaps.
Yes, please.
Yes. Your Worship, I kindly take up the section 22A. 60. What of sir? Kindly give 67.
22A of Registration Act.
Yes. What of sir? 67.
67 of registration. Yes.
Yes.
We will hear you on 14 September, correct? No, not 14th. 14th, we have fixed some case. On 26 September, right?
Yes.
Give the list. Mark the presence, learned Advocate General undertakes to furnish the list of rate petitions which are to be heard along with this bunch of rate petitions. List on 26/9/2023.
Yes,
22.
So that virus.
All right. That binds us. Which full bench? You say which full bench? 343 of 2015. Judgment dated. By full bench.
Yes.
All right. 1 minute.
That was not a challenge in that. Section 22 was not.
Whatever. We are just recording his submission.
Yes.
So that for the facility of reference next time, it must be reported.
Reported. It's a judgment.
It is a. Offline.
2016 2 ALD 236. 236 is a full bench.
236. So before that he shall give no. Learned Advocate General submits that the issue with regard to validity of section 22A of the Registration Act.
It's not dealt. That full bench is not dealt.
Mr. B, his submission is entitled to argue anything. We just want to understand what is submission. Alright, so Learned Advocate General submits that the issue with regard to validity of section 22A of the Registration Act has been dealt with by by a full bench decision of this court in the case of so and so versus so and so, 2016 volume 2 ALD 236. However, learned counsels for the petitioner dispute the aforesaid submission and point out and submit that the full bench of this court has not dealt with virus of issue with regard to virus of section 22A of the Registration Act. Then you write, learned advocate undertakes to furnish list, and then we have given a date to what date?
26.
My lord, I beg to appear in this matter. My lord, I beg to appear in this matter. Am I audible to my lord?
Yes, yes, you are audible and visible also.
Yes, correct.
Yes.
This writ appeal.
1 minute. Who appears for? Yes, madam, ready? Yes. Yes, please.
Revenue Department, my lord. My lord, this particular writ appeal is arising out of an order of resumption passed under the provisions of the Assigned Lands Prohibition of Transfers Act 1977. The background facts are this, my lord. Under the Agricultural Sealing Act.
1 minute, Mr.
Yes, my lord.
Yes.
Under the Agricultural Sealing Act, that is 1973 Act, the surplus land which has been surrendered to the government will be disposed of as per section 14 of the Act, which is extracted by the learned single judge at page number 20 of the paper book, paragraph number 13. Well, without troubling your lordship by reading this, disposal of the surplus land in favor of the agricultural labor or artisans on payment of installments for 15 years. And the provision says that the government will dispose of the surplus sealing land to the agricultural artisans and the agricultural labor on payment of the land revenue as specified in section 14 subsection 2 of the Agricultural Sealing Act 1973. The writ petitioners are the writ appellants are the writ petitioners. They were granted this particular, they were given this grant of the agricultural land, and they have completed the payment of 15 years installments, and as per section 14 subsection 2, on payment of these 15-year installments by the government, they will be given patta in respect of the subject land. This is under the Agricultural Sealing Act. There is another act, that is AP Assigned Lands Prohibition of Transfers Act, which prohibits assigned land from being alienated by the assignee when there is a condition of inalienability embedded in the order of assignment. These two enactments will play on different planes, that is AP Agricultural Sealings Act 1973 and AP Assigned Lands Prohibition of Transfers Act. Learned single judge in this particular case has held that even if the 15-year installments are paid by the allottees of the land, though they are supposed to be given patta, still they cannot alienate the land, and alienation would result in the situation of resumption of the land under the Assigned Lands Prohibition of Transfer Act. My lord, your worships perhaps must have come across this Manchegowda case of Karnataka, where the Supreme Court said, my lord, that a permanent condition of non-alienability is per se invalid and not permissible.
Contrary to section 8(5) of the Transfer of Property Act.
Correct. Contrary to section 8, 9, 10 of the Transfer of Property Act. And now in the present case, my lord, what happens is this. Despite the fact that the allottees of agricultural land have completed the payment of 15 yearly installments, still they are subjected to the proceedings under the AP Assigned Lands Prohibition of Transfer Act. And since they have indulged in sale of the land after completing the 15-year installments, the Tahsildar, who is the competent authority under the Assigned Lands Prohibition of Transfer Act, has passed an order of resumption, resuming the land from the writ petitioners, writ appellants, and recorded that it was with this state. So that resumption proceeding, my lord, was called in question before the learned single judge in the writ petition. Learned single judge upholds the resumption order and dismisses the writ petition. That is how the writ petitioners are the writ appellants before my lords. The two relevant provisions, both these acts, my lord, this Agricultural Sealing on Holdings Act 1973 as well as Assigned Lands Prohibition of Transfer Act 1977, both contain non-obstante clause that the provisions of the statute will have overriding effect over all other laws for the time being in force. Learned single judge has noticed the non-obstante clause contained in the Assigned Lands Act and did not take into account the non-obstante clause contained in the Sealing Act. 1973 is Sealing Act, 1977 is the Assigned Lands Prohibition of Transfer Act. Well, the judgment of the learned single judge has a far-reaching consequence that despite the fact that the persons have completed the payments and they are to be given a patta statutorily under section 14 subsection 2 of the Land Sealing Act, they still continue to suffer the disability of being unable to sell the land despite the fact that the land might have become a house site or the agricultural operations have ceased to exist. So this particular judgment of the learned single judge has a cascading effect on several cases in this particular line. Therefore, if my lords permit me, because today I am running fever, therefore I could not come to physical court. My lords may kindly give a convenience to me, my lord. I think I should come and argue physically this particular case in the physical hearing and not the virtual mode.
So when, Mr.
Anytime, my lord, your lordship may have it next Monday.
Next number is 56 case.
Because
Yes, learned senior counsel for the appellant prays for a short accommodation list on 11 September 2023.
Applies.
May it please, my lords. I beg to represent Vivek Jain, your lordships. My lord, this matters pertains to Halafnama. My lord's learned single judge has dismissed my writ petition on the ground that I purchased the land from a non-tribal by virtue of Halafnama prior to 1970. My lords, I passed on the brief synopsis on the last occasion.
Yes, go ahead.
My lords, on the last occasion, your lordships have put a query on me that whether the word transfer under the AP schedule.
You forget about query. This is, you argue your case, it's a different combination.
Yes, my lord. My lords have asked me whether it.
No, please. Who will, this is for final hearing, right?
Yes, my lord.
Stating the facts.
Yes.
My lord, not stating, jumping to query, I don't know.
My lord's facts are like this. On 25/6/1968, I have purchased the land to the extent of 20 acres from non-tribal My lords, in Vadagaon village, Indravalli Mandal, Adilabad district, through Halafnama, which is an unregistered document, my lords, from a non-tribal. My lords, on 3/2/1970, amendment was made to this regulation, AP Scheduled Areas Land Transfer Regulation, which prohibited even transfer from a non-tribal to non-tribal. On 29/4/1970, my lord, I got an I got a sale deed registered in my favor by means of a registered document. Thereafter, my lords, respondent number 3, which is the agency authority, they have initiated the proceedings under the regulations of 1959. While order dated 21/12/1984, my lords, they passed the order directing, saying that on the ground that Halafnama being an unregistered document has to be complied with Stamps Act and Registration Act, against which I preferred an appeal, my lord, that was dismissed. I preferred a revision, that was dismissed. My lord, then I came writ petition before this, before the honorable, this honorable court, learned single judge, my lords, while order dated 9/9/2007 has dismissed my writ petition on the ground that initial transaction, which was through Halafnama, is hit by this 1970 regulation because it was prior to that regulation, and that Halafnama is an unregistered document. My lords, my respectful submission is this. My lords, first, the 1970 regulation comes into force prospectively. And second submission is that, my lord, respondent number 3 ought not to go into the aspects that don't have jurisdiction to the aspect of dealing whether Stamps Act or Registration Act apply or not, in view of judgment of a full bench of this honorable court, my lords, in Gaddam Narsareddy versus Collector 1981 2 APLG 260. And third submission is that, my lords, the word transfer under section 2G of AP Scheduled Areas Land Transfer Regulation Act has a wider meaning, my lord, which covers the word other dealing, land transfer and everything, because of which, my lord, even an unregistered document comes under and gets saved under it. Even the honorable apex court, my lord, in a 2019 judgment, when the
like any other dealing means principle of ejusdem generis has to be applied.
Yes.
For reading this expression, any other dealing.
Yes, my lord.
If the words preceding any other dealing are referring to registered documents, this any other dealing will also be registered.
Yes.
Can't be unregistered.
Yes.
Yes, anything else?
No, yes, my lord. That was the query which your lords have put on me. My lords, may I submit this? My lords, may I see the definition of word transfer?
No, full bench, what your...
My lord, it says the authorities do not have jurisdiction to go into all these aspects of whether Registration Act, Stamps Act and all this apply or not. I passed on the judgment on the last occasion, my lord. It's Gaddam Narsareddy versus Collector. It was followed by single judge also, by the learned single judge of this honorable court in subsequent judgment. Gaddam Narsareddy versus Collector, my lords.
Yes, madam. There. Another copy. Yes.
My lords, para 18 of that judgment, 1981 2 APLG 260. Para 18, my lords.
Yes.
My lords, may I read, my lords? So far as the latter submission is concerned, it is clear from the provisions of section 32A of the regulation that the agency or agency divisional officer or other officer mentioned therein can only pass a decree of ejectment against any person in possession of property claiming under a transfer from a tribal where such transfer of immovable property is made
1 minute, 1 minute. Yes, now read it again.
Therefore, the jurisdiction under section...
No, read from the beginning.
I'm sorry. So far as the latter submission is concerned, it is clear from the provisions of section 32A of the regulation that the agency or agency divisional officer or the other officer mentioned therein can only pass a decree of ejectment against any person in possession of the property claiming under a transfer from a tribal where such transfer of immovable property is made in contravention of subsection 1 of section 3. Therefore, the jurisdiction under section 3(2) of the authorities mentioned therein to pass a decree of ejectment is limited to determine the question whether the transfer effected is made in contravention of provisions of section 31A and B. My lords may skip that. My lords could find at next page the relevant wording, my lord, which page number 267. Third line, my lords. My lords, to such a transfer falling within the purview of section 31A, the provision of the Transfer of Property Act or the provisions of Transfer of Property Act or the provisions of Hyderabad Tenancy and Agriculture Lands Act or the Indian Registration Act would not apply. My lord, that was followed by another single judge of this honorable court, my lords, in a 1999 judgment. It is Kulla Mahalakshmi versus Agent to Government, Khammam, 1999, 3 APLJ 509.
No, but your this thing proceeding was not for ejectment of against any person in possession, right?
My lords?
Your claim was for ejectment of any person in possession.
I was in possession of that land, my lords.
Somebody for challenge is saying.
No one challenged, they took it suo moto.
No, you had initiated the proceeding to register this thing, no?
My lord, after 1968, when this regulation came into force, I got a registered document in my favor. At that time also no one objected to it. All of the sudden, my lord, suo moto, the agency takes the jurisdiction and it passes this order.
So, see, in the proceeding pertaining to your eviction,
yes, my lord,
the question has been gone into which you are saying that it can't be gone into.
Yes, this is my first submission
of this division bench.
Yes, full bench.
Full bench. Full bench.
That is my first submission, my lords. Assuming, my lord, that is not considered.
All right.
What transfer, my lords, has a wider meaning. My lords have asked.
It will include unregistered document.
Is my respectful submission, my lords.
Yes.
Because
third submission is what?
This transfer, my lord. That is my submission.
This is second.
First submission. First submission is that, my lord, this 1970 regulation is prospective in nature. It cannot apply retrospectively.
Yes.
In view of the judgment of the Honorable Supreme Court in 1995. Third submission is this, my lord, the word transfer. My lords may see it uses the word contract as well. My lords, any sale, gift, and all this, my lord, require registration. The word contract, my lords, under section 10, even oral contract agreement can become a contract. My lords, even, my lords may see, lease, sale, gift, exchange. Few among these, my lords, do not require registration. For instance, my lord, mortgage. My lords, mortgage by simple mortgage, mortgage by deposit of title deeds. Honorable Apex Court in a 2014 judgment, my lords, went on to say that mortgage by deposit of title deeds, just have to deposit the title deeds and that would suffice to bring it under the ambit of mortgage. It doesn't need any instrument per se, not even any registered instrument, my lords. These are few of the provisions, my lord, because that's why, my lord, the doctrine of egestem generis won't apply. But for doctrine of egestem generis to apply, it should contain of the same genus, then the specific words would fall under that. My lord, but these words, the use of word contract in the statute, by use of word lease, sale, exchange, few among them, my lords, do not even require registration. Therefore, my respectful submission is that it comes under the ambit of word transfer, which has a wider ramification, my lords. It doesn't, what's confined to this, and doctrine of egestem generis wouldn't apply, my lords. This is my respectful submission. Because, my lord, the word any is used.
Yes, yes. Anything else?
That's it. I have given the brief synopsis.
Yes. Yes.
Obliged.
You have argued it well, Mr. Keep it up.
Obliged.
Yes.
Action between the
core issue is 3.
The key issue.
One by one.
Yes, Lord.
Answer one by one.
Yes, Lord.
First is amendment to the regulation does not apply retrospectively. Second is with regard to full bench. Third is interpretation.
Lord.
Lordship, as you know, Lordship, as you know pretty well, the transfer of immovable property through affidavit, which is not permissible by law. That is my first bullet point, Lordship. Absolutely null and void. The transaction, it has to be done through this particular statute, it has to be done in a particular manner. There is no immunity for the Registration Act, as well as the Stamp Act, as well as this agency law. So therefore, the transaction took place, it is an admitted fact through the affidavit, which is not permissible by law.
You have given, my lords. On last occasion, my colleague has.
Synopsis you have got.
I'm sorry.
Yes.
Second is, Lordship, that the judgment has no application, Lordship, that I agree fully, which is operate prospective effect. That the transaction took place, sale deed, which is at page number, Lordship. The Leonard single judge made it, which is at page number 10, Lordship. The Leonard single judge finding, Lordship, which is at page number 10. May I just read out? He submit that admitted the sale deed in his favor was executed on 29/4/1970 after coming into force of regulation of 1 of 70 with effect from 3/2/1970. Therefore, the transaction is void.
All right. See. Yes.
Hence, my appeal may be allowed, my lords.
He is arguing, you are saying appeal may be
I'm
allowed.
sorry.
That you will follow.
I'm sorry.
You will see what happens to your appeal.
I'm sorry.
Lordship, section 54 of the TP Act, Lordship, as you know pretty well, and section 70.
What pretty well, what is this?
I'm sorry, I'm so sorry.
Yes.
Lordship, the sale deed is
Mr.
compulsory.
Transfer.
Lordship, the transaction has not.
So transaction after amendment of the regulation. So therefore, question of prospectivity, retrospectivity does not arise. It's not that like you will say correct. We are judges.
I'm great.
You cannot say. All right. Anything else?
Nothing.
Nothing.
Maybe the transaction.
Please argue, mister. Don't take it that it's being dismissed.
Lordship, my respect.
I mean, you have not answered the full bench. You have not answered whatever third submission. Ejusdem generis will apply or not. Nothing, and you are saying nothing.
My respectable submission is, Lordship.
You will say that you are saying nothing.
Lordship, my respectable submission is, Lordship, transfer of immovable property through affidavit, which is not permissible in the eyes of the law. That's a first and foremost submission, Lordship. Therefore, the transaction itself null and void in the eyes of the law. The affidavit through the valid transfer, Lordship, my experience is it is in a vehicles or something, it is in a movable properties, not by way of this immovable properties. It is a settled law. Lordship, my friend saying 2C definition, Lordship, which he interprets whatever he suits. But my understanding 2G, which includes Lordship rightly pointed out, it's a wider meaning. Transfer 2G,
You
Lordship.
don't have any business to give us certificate we are right or wrong.
I'm
Or
so
rightly
sorry.
and all this.
Lordship,
You should have brought this thing, what is the jus generis when it applies, just in my opinion.
Lordship, my understanding, Lordship, 2G
A
transfer.
very good way of, we wish we could write a judgment like you according to our understanding law is like this and therefore petition is dismissed or allowed. Is this the way of arguing the case? All right, go ahead.
Lordship, 2G transfer means mortgage with or without position, lease, sale, gift, exchange or any other dealing with immovable property, not being a testamentary disposition, and include a charge on such property or a contract relating to such property in respect of such mortgage, lease, sale, gift, exchange or other dealing. Except Lordship will deed, it has to be transferred through the registered. That is the 2G definition, Lordship, for a complete understanding. The primary authority, appellate authority, and regional authority concurrent findings against the petitioner, Lordship.
Unregistered affidavits. And therefore, yes, that's it, Mr. Anything else?
My respectful submission is that the word.
It should be allowed.
No, yes, my lords.
All right, reserved.
Submission is the word any is given a wider interpretation, even though my lords in the authority.
Mister, you are not getting the facts correctly. This regulation was amended on 3/2/70 prohibiting, prescribing a prohibition. The sale date has been executed thereafter. Where is the question of retro application and all that? Doesn't correct.
Affidavit was there. My lords, 1970.
Mr. Affidavit is after.
No, on submission, it was prior to.
Sale deed was registered.
Yes, first halafnama came. My lords may see the contents of the halafnama. As every footing of a contract, my lords, transaction.
Then why did you execute the sale deed? If according to you, by unregistered document, property can be transferred, what was the need of execution of sale deed? No need.
Yes, my lord, to be on the.
Yes.
It contains every recital that a contract needs, my lord, requisite of a contract.
Fine.
Every thing that is needed for a contract, halafnama contains that, my lord.
Then why did you got the sale deed executed? Please tell us.
Sale deed was
in 29/4/70. Why it was got executed if it was a sale according to you 25/6/1968?
Yes, my lords.
Nothing. Yes. Mark the presence. Whatever order dictated.
I was
Yes.
respondent number 4, my lord, he the petitioner.
Nobody is appearing.
He the petitioners.
I'm appearing for the.
Come here. All this we have kept all along, these petitioners is still not accustomed. Yes.
I apologize in this matter, my lord. This matter, my lord, already this matter.
Unregistered document.
Yes, my lord. In this matter, my lord, we already filed a memo, my lord, wide SR number 36371 of 2022, my lord. A memo
To do
was,
what? Memo.
along with a document, we filed a memo, my lord.
What is the memo?
Well, in this matter, my lord, the already once a matter was decided, my lord, dismissing the.
Then why did you file a memo? It's an appeal, right? Argue on the appeal. Why did you file a memo? Was there a direction to file any additional document?
Yes, my lord, it was a document, my lord, we filed because earlier.
Please argue, Mr. The appeal on merits.
In this matter, senior counsel is.
No senior counsel. You are senior counsel. Yes, yes.
Okay.
Brother has designated you as senior counsel just now, he told me. So now for this case, you are a senior counsel. Please go ahead. Tell senior that the court did not adjourn. What can you do?
In this matter,
No, nothing.
Yes.
Forget about it. Yes.
This matter, my lord, the earlier also, my lord, the respondent number 3, my lord, has filed an application before the special deputy collector, my lord, for the delivery of possession, my lord. White case number, my lord.
Question of fact cannot be, the principle is, question of fact cannot be adjudicated in a writ petition and it cannot be re-adjudicated in a writ petition.
Yes, my lord.
That's it.
Because in the
That's why your petition has been dismissed.
Yes, my lord. Because in the court below also, my lord.
Yes, take it. Fine.
My lord, because in the court below also, my lord, the
court below.
It is a res judicata, my lord.
All right. Yes.
At least
Heard submissions of
your lordship could kindly hear me for a moment. The lordship could kindly take up the matter tomorrow.
Nothing.
I'll prepare myself on the matter.
No, nothing. Nothing, mister. It's not being adjourned.
Some are
No.
At least
We want to give this message loud and clear that the request for entertainment, especially made by young advocates, will not be entertained. Nothing.
At least at the end of
Nothing. You read the order. It's very clear. We have told you that issue of fact cannot be re-adjudicated. We have told you.
Yes, my lord. But the principle is, my lord, the matter is already been decided in an application filed with the same respondent, my lord, and the special deputy collector, my lord, has rejected their application, my lord, and their case was dismissed, my lord. And no appeal was preferred against that case, my lord, and it has attained finality, my lord. Again, they have filed a fresh case, my lord. In that, my lord, it has been adjudicated that it attracts a regulation act. Because, my lord, when the case is already decided, my lord.
Why have you stood up? Sit down. Sit down. Please sit down. Why have you stood up? He's still arguing. Yes. Yes, please.
My lord. Because already a case has been decided, my lord. We have pleaded in our grounds, my lord, in the courts below, my lord, that it attracts a res judicata and a fresh case cannot be initiated against the petitioners, my lord. Because it has attained a finality, my lord. They have never preferred an appeal against that order, and it has become and it has attained a finality, my lord. And if your lordship would see that, my lord, that case, my lord, which we filed a memo, my lord, concluding paragraph, my lord, petitioners, my lord, who is none other than the respondent number 3, my lord, who filed the case before the court, my lord, the special deputy collector, my lord, as finding that, my lord, petitioner admitted that the sale of the land to the Gunda Lakshmi Narsaya
was prior to the sale of the land to the other respondents. According to the sale deeds filed by the Marika Bazar Yallar Buchireddy, the sales were effected in the year 1962. The sale deeds, LR receipts, Panchayat fee receipts, and other evidences show that the land had measuring 5 acres in survey number 185 of Madulapalli within the boundaries specified was sold prior to 1963. Petition dismissed, my lord. So, my lord, this has attained finality, my lord. Again, a fresh application has filed by the same respondent before the same authority, my lord.
The adjudicator should have been answered in your favor, saying that you cannot be vexed twice.
Yes,
for the same cause.
Yes, my lord.
Right? This is the submission.
Yes, my lord. Because
you have argued very well, Mr. Why should you seek adjournment? Because this is the point, short point, and you have put it very clearly. Yes, Mr. That's it. Anything else?
Because in the court below, my lord, we have taken a stand and grounds also, my lord, that this advice, my lord, before the special deputy collector and before the collector, my lord, in CMA and before the writ petition also, my lord. And one more ground is that, my lord, after the expiry of the respondent number 3, my lord, his brother's son was brought as the LR, my lord, in spite of his daughter is being alive, my lord. Because he is not the LR, is our contention also.
All right.
Only two submissions, my lord. I'm appealing for the respondent number 4. The respondent number 4 came into position on 6/7/1990. They have filed some memo stating that adjudicator will apply because of the previous case has been decided. Due respect to this honorable court, this document was not filed before the primary authorities, state authorities, even though they have taken plea in the writ petition. It was not filed a document. Moreover,
what is the effect of that order? What is the effect of that order?
nothing is there. According to my submission, adjudicator will not apply to the case. My lord shall aware that proposition of adjudicator with the same party, same relief. It is an agricultural land. Survey number is a very crucial. The document which was filed before this court along with the memo.
Pertains to different survey number.
Survey 185. This is the 185 to 254. There was a specific government made in the counter. Page number 21, my lord. Page number 22 has given specific finding.
Please go to page 3, internal page 3 of the order. Order passed in WP 21839 of 2001.
Yes, sir.
Please read from, in this case, the petitioner in the grounds of appeal. Please read from. How do you answer that?
In the writ petition challenge, the order of the appellate.
No, in the order, WP 21839 of
2001, my lord.
Yes. Go to page 3, the last portion,
The appellate authority also found, well.
In this case, the petitioner in the grounds of appeal or on the oral grounds before that.
Yes,
from there.
or on the oral argument before the first respondent never raised any ground to the effect that transaction was not regulated.
Read further.
In so far as the order of the appellate authority is concerned, it is found that in the revenue records from 1959 to 60 to 72 to 73, the name of the third respondent was shown as Patelas and the name of Katti Muttaya, Yelka Tirapaya and Gundrati Narsaya were interpolated with different ink and handwriting in the Pahani for the year 1963 to 64. The appellate authority also found that the sale deed dated so and so was executed by Lakshmi Narsaya and Tirapaya on a stamp paper of ₹3, and the same being an unregistered document, it cannot be admitted as evidence in proof of sale in favor of the petitioner. In view of the matter, the same is being question of fact, it cannot be re-adjudicated in writ petition.
All right. Anything else, Mr.
Only this adjudicator will not apply because survey number parties are different. Number 1.
That we have noted, right? Third argument reserved, judgment reserved. Next.
That was the survey number, my lord. The parties are very much the same, my lord.
Yes, next. Yes, Mr. 98 matter.
Yes.
Huh?
Yes. The petitioner before your lordship, EPF organization, but the petitioner challenged the orders passed by the
Provident Fund
EPF
Commission. What is this?
tribunal, but whereunder the EPF 80 allowed the appeal filed by the R2 respondent number 2 Milan. A batch of petitions filed Milan by the EPF.
Employees Provident Funds Act, right?
Yes,
1952.
yes,
What is the order?
That,
Order passed by the competent authority and the appellate authority.
competent authority Milan,
Yes.
EPF Milan claimed the damages Milan under 14B.
14B.
The period from 1978 to 85.
What was the quantum of damages?
85. During that period, there was stay granted by the apex court with regard to notification issued by the EPFO. Ultimately, the Supreme Court dismissed their case. Due to which, after completion of this process, the EPFO claimed damages. Against this, the EPFO order, the second respondent approached the EPF 80, EPF 80 allowed a batch of cases. Against which we filed a batch of cases here.
What has happened to other batch? You have the order?
Yes.
What happened?
The batch of cases adjudicated by this other division bench of this.
What has happened?
Dismissed.
This also goes. Yes. Mark the presence. In this writ petition. Next. At 450. Yes. So remaining cases will continue tomorrow.
Lords,
Yes, Mr. Srivastava.
yes, Lords, may I have a small indulgence, my lords?
Yes, please.
88, 89 and 90, my lords, are the matters
Yes.
In which, my lords, I beg to appear for the respondents.
Yes, yes.
Respondents. Instead of tomorrow, could your lordships have it, my lords, next week or any other convenient date, my lords?
Yes, who appears for the appellant? Mr. Advocate General, 88 and 90 next week.
We request 2 weeks time, my lord. We need
2 weeks.
brief note.
Mr. Srivastava, you are also joining in with your request. Instead of 1 week, you are saying.
In fact, if your lordship is pleased to fix it on 21st of
21st.
I would be very happy to appear in physical, my lord, sir.
Yes.
21st.
21st is okay.
Lordship's convenience.
21st.
21st September. Subject to
Thursday. Thursday. Yes, we'll have it on that day.
Very good.
Might be presence.
AJP
Kiran. Yes, yes. Learn it. What's your name?
Kiran, my lords. Kiran, assistant government.
What is like your GP?
Kiran,
Huh?
D. Kiran.
No, that's correct. What is your designation?
AGP, my lords. Assistant government.
AGP. AGP. Praise for praise for adjournment to enable him to prepare the case and argue the same. List on 21st September. 88 and 90. Item 88 and 90.
Deeply obliged.
My lord, item 38, Lord. It will continue tomorrow. You want adjournment?
After a week, if you want. After a week. Because I don't have government papers. They have not thrown on me.
See, you can't have 24 years it's pending. The client must have lost interest.
No,
Lordship permission, lordship.
I'll take care of it. After a week,
It's 99 matter.
is there collected? And also,
No, Mr. C, senior counsel, if you adjourn 99 writ petition, we have to adjourn every other case. Please ask your young person to take away our paperwork. We will return it tomorrow. And still argue tomorrow. In any case, we are not taking up the matter. No. Sorry, our apologies to you. Sorry.
With your lordship permission, lordship. Item 92 also connected lordship to the batch. 88 to 92. 87 to 92 lordship. 88 to 92, my lords. They have taken 92 also.
To 92.
Yes, lordship.
Then you should have said no.
That is it.
88, 89, 91, 92 also
Yes,
21st
yes.
September.
Yes. Obliged.
has been argued before us.
Yes.
Legitimate expectation.
Yes, on creeper.
First, relying on the
Legitimate expectation.
file.
Yes. Yes.
Legitimate expectation, making amendment. One second point is making amendment to a non-existing rule.
Yes, I take
Which
your
is
last.
there 4-3 something. No, we are just telling you what all has been argued.
Yes, that's true. My friend has put these arguments on 3 points, my lord, as your lordships indicated. One is that
Yes. Legitimate expectation.
Yes.
Number 1, no rational nexus between the act and the object sought to be achieved. Number 2.
Yes.
Number 3 is validity of Article 14.
yes, that's true, my lord.
Number 4 is it seeks to alter the position existing on the date of notifying the entrance examination, which is not permissible in law. And amendment shall have the effect of reducing the number of seats under NCC quota, and this thing amend rule 4, which does not exist.
Yes, exactly. No, first I take your lordships to GO, which is under challenge. Principle of legitimate expectation, doctrine of promissory estoppel and waiver where it can be invoked. When authorities exercise power under statute.
Put it. Go and put it under shudder. Yes. Yes, Mr.
My lord, in a writ affidavit, my lord, page number 19. This is admittal paper accompanied by the
affidavit, page number
19, my lord.
Yes.
Page number 19, my lord, notification. If lordship permit me to, I go to the notification, my lord. In excess of the powers conferred by section 3, read with subsection
15(1) of the
section 3. Section 3, I take your lordships, the Education Act. This act is called AP Education Institutions Regulations of Admissions Prohibition of Capitation Fee Act. Your lordship may kindly
How we have, all this has been told to us, by Mr. Prabhakar Rao in previous bunch. 3(1), 15, etc. We have answered. These rules have been framed under 3(1) and 15 also.
Yes. Then
3(1) is what?
my life has become easy now. My job has become very easy.
You said life has become easy.
I cannot struggle for.
We can't do anything about it.
I will not struggle much to explain to your lordship. That's why I said deliberately use it. My life has become easy to. Section 3, your lordship may kindly see. Section 3. This is enabling authorities to pass orders, much less called GOs. Section 3, melody. Regulations of admissions.
No, you have this.
Andhra Pradesh Educational Institutions Regulation of Admissions and Program. Page, my lord, if your lordships carry same book, my lord, page number at Sarkar 80, page number 81, my lord. Page number 81. My lord, relevant section at page number, my lord, 87. Regulations of admissions into education institutions. Subject to such rules as may be made in this behalf. Admission into education institutions shall be made either on the basis of the marks obtained in the qualifying examination or on the basis of the ranking assigned in the entrance test conducted by such authority, and in such manner as may be prescribed. Provided this medical admissions also come under the sweep of this section, provided that admissions into agriculture, dental, engineering, medical, pharmacy and veterinary college shall be made on the basis of the ranking, so on and so forth. My lord, the GOMS 75 is issued in excess of this power. Read with the section 15. 15 is the enabling provision to frame the rules in order to carry out the objects contained in this act. This is what rules. My lord, this rules 15. My lord, I need not much trouble your lordship by reading all these provisions. Rule 15 enables the government to pass the GOs in order.
Section 15.
Section 15, sir, section 15. My lord. 15.
Yes.
That is at page number 15, my lord. Page number 91, my lord, to make rules. The government may by notification make rules for carrying out all or any of the purpose of this act. My lord, this GOMS 75, my lord, has been issued in excess of the power under section 3 and read with section 15. Now your lordship may kindly come back to page number 75, my lord. This page number 75, the page GO 75, at page number 21 of the matter paper filed by the petitioner along with the writ petition.
Page
21, my lord. Rule, here now rule, subclass 2, my lord. In rule 4, your lordship what, my lord? In rule 4, class 3, and paragraph thereafter, the following class shall be inserted, namely, grace mark for NCC. Instead of the reservation, by the GOMS now substituted and incorporated, instead of reservation of percentage, now incorporated grace mark for NCC only. These grace marks are given, my lord. My lord, earlier provision in GOMS 114, your lordship may kindly see, page number 42. 42. This earlier GOMS 114 begins at page number 38, relevant classes at page number 42. These are the provisions which are substituted and incorporated grace marks instead of the reservation to the extent of 1%. Class 4, horizontal reservation of seats. Your lordship may please to my friend is very emphatic on this, which are wrongly quoted or misquoted. It is said to have been like that. My lord, number 40, rule 3. This deals with class 3, page number 40. I am taking back to rules of reservation for admission area. Rule 3, page number 40, my lord. Rule 3, this class deals with the
Rule 3.3.
Roman 3.
That is number 3, Roman 3.
Yes. Number 3, eligibility criteria for admission.
And Roman
3, rules of reservation for admission area. Now, my lord, again at page number 42 is again reservation of seats.
Page number?
Page number 42. Roman 4.
Yes, yes.
Now, class C is now deleted. But national cadet corps, 1% reservation was there in the earlier GO. That is all GO also was issued in excess of the power conferred under section 3 and section 14 of the Act, which a little while ago I read out to your lordship. My lord, next page, my lord, your lordship may kindly see.
When you say class 4, you are referring to Roman 4 or class 3?
I should admit, my lord, there is one typographical mistake in. My lord, wrong quoting, misquoting, that my lord will not change as far as the
number 3 should have appeared.
Yes. Number 3, C should have been appeared.
C.
Here, my lord, C. Roman 4. Roman 3, 4, C must have been appeared, but while oversight, but due to inadvertency, this rule C has not been reflected in the present GO. That is an inadvertency, my lord.
You have said rule 4, number 4.
No, Roman 4.
No. In the amendment, you have said number 4.
Number 4. Yes, yes.
So you should have said. You should have said 3, 4, C.
Yes.
3 within bracket with this.
That is inadvertent.
Roman 4 and C.
Yes, that should have been stated. Frankly speaking, 4 Roman 4, Roman 3, C must have been stated, but it is.
You have said rule 4.
Yes, that is.
That does not invalidate.
That does not invalidate as long as the authority who issued GO have the power. If the power is traced out to the Patent Act, Main Act, it is nothing but exercising statutory power.
All right.
That is the HL Harla judgment, 1974, 4 SCC. Supreme Court, following the judgment, this Honorable Court, even in 2016, followed the same.
Which judgment?
HL Harla case, 1974, 4 SCC. I'm circulating. I'm sorry, HL Mehra Mallet. HL Mehra.
That's why we were slightly confused.
Yes.
What
HL Mehra judgment, Mallet 74.
page number?
Page number, Mallet 96. I am passing on.
No, so long as power exists, doesn't.
Yes. Misquoting.
Mere wrong quoting of provision will not invalidate.
We set the proceedings under challenge. Para 8, my lord, your lordship may kindly. Para 8, 97, running page 97, my lord.
This is accepted.
Yes, accepted. This court also. This honorable
No,
court.
this legal principle, even he cannot dispute. He can't argue contrary to Supreme Court.
It's no longer res integra, my lord. It is law. It is no longer res. Before your lordship, I can say authoritatively it's no longer res integra. This law will set it. I say
yes. Next submission.
Melody, next point, melody, your lordship may kindly see. Invocation of the legitimate expectancy. When statute itself deals and empowers the government issue the GO, which is that the provision of the doctrine of legitimate expectancy, promissory estoppel
doesn't apply to exercise of legislative power.
Yes.
This is the submission.
Yes, I think that.
Right?
Yes.
Any case.
Well, on this, Millet,
legislative power, which case law?
Yes. Millet, I passed on the judgments, Millet.
Which judgment? Tell us.
Judgment, Millet, T. Sushila and others versus University Grants Commission. Page number, Millet, running page number.
So you have annexed in reverse order, right?
Yes, Millet.
So,
page number 114, Millet, running page number 40. Instead of reading all paras, Millet, I may take your lordship.
It is not 2015.
19.
SCC.
19.
1 minute. SCC 129.
Yes, Millet. 2015 8 SCC page number 120.
Para 16.
Oh, yes, Millet. Para 16, 19, 20.
What is it?
Yes, Millet.
Read one line. Doctrine of legitimate expectation does not apply to legislative power.
Yes.
Read that line.
Yes, Millet. Similarly, Millet, in UG's time reading, please. The challenge was made to exemption granted, Millet. Doctrine of, para 19 I'm reading, Millet. Doctrine of legitimate expectation has been dealt with in two judgments of this court as follows. Millet, Honorable Supreme Court, while extracting judgments, Millet, page 20. Similarly, in Seth versus so and so, it is well settled that the concept of legitimate expectation has no role to play where the state action is as public policy. Para 20, I'm reading, my lord, at page number 15, running page. Is as public policy or in a public interest unless the action taken amounts in abuse of the power. The court must not usurp the discretion of the public authority which is empowered to take the decision under law, and the court is expected to apply an objective standard which leaves to deciding authority the full range of choice which the legislature is presumed to have intended. Even in a case where the decision is left entirely to the discretion of the deciding authority without any such legal bounds, and if decision is taken fairly and objectively, the court will not interfere on the ground of procedural fairness to a person whose interest based on the legitimate expectation might be affected. Therefore, the legitimate expectation can at the most be one of the grounds which may give rise to judicial review, but the granting of the relief is very much limited. So on and so several judgments are again cited by the Honorable Supreme Court, and it may read all the paragraphs related to the same.
we don't know you are arguing the case.
Yes.
If it is necessary,
21, my lord.
not we only said that your proposition is correct, right?
Yes.
The legislative doctrine of legitimate expectation cannot be invoked in
a statute as well as the public policy.
now the which is that paragraph.
Yes.
That's what we are asking you to read. That's it.
Yes.
There are judgments and judgments on doctrine of legitimate expectation.
There are
Starting from MP Sugar Mills case. Yeah.
Yes.
So don't go to 1978. Me in 23 only. In September. Yes.
There are 35 next.
35. No 35, mister. The judgment ends at para 25.
Millet.
Some other.
Page number 35, my lord, your lordship.
This is some.
Para 21, this another judge.
Page 30.
My lord, this is in 2005, 1 SEC, page number 625.
This is 2005 judgment.
2005 one. My lord, Mannari Amman Sugar Limited versus Commercial Tax Office and others. My lord, yes.
Para
8, my lord, before I take your lordship.
Para 21.
Para 21.
That is at page 36.
Page 36, mil. In view of the factual position recorded by High Court that at the point of time the appellant units were set up and the commercial production started, there was no assurance or promise. The doctrine of promissory estoppel had no application to the facts of the case. At that stage, we find no sustenance in the plea before a policy decision is taken to amend or alter the promise indicated any particular notification. The beneficiary was to be granted an opportunity of hearing. Such a plea is clearly unsustainable. While taking policy decision, the government is not required to hear the persons who have been granted the benefit which is sought to be withdrawn. The Lordship much detailedly discussed at paragraph number 8, my lord. Your Lordship may come back to paragraph 8 of the same judgment. At page number 30, my lord. Last lines of this paragraph. Page 30, my lord. Paragraph 8. A person may have legitimate expectation of being treated in a certain way by an administrative authority, even though he has no legal right in private law to receive such treatment. The expectation may arise either from the representation or a promise made by the authority, including an implied representation, or from consistent past practice. The doctrine of legitimate expectation has an important place in the developing law of the judicial review. It is, however, not necessary to explore the doctrine in this case. It is enough merely to note that a legitimate expectation can provide a sufficient interest to enable the who cannot find the existence of the substantive right to obtain the leave of the court to apply for judicial review. It is generally agreed that legitimate expectation gives an applicant sufficient locus standi for judicial review, and the doctrine of legitimate expectation to be confined mostly to a right of fair hearing before a decision which result in negating or a promise or withdrawing an undertaking is taken. The doctrine does not give scope to claim relief straight away from the administrative authorities. As to crystallized right, such as is involved, the protection of such legitimate expectation does not require the fulfillment of expectation where an overriding public interest requires otherwise. In other words, where a person's legitimate expectation is not fulfilled by taking a particular decision, then the decision maker should justify the denial of such expectation by showing some overriding public interest. But at DRE, I wanted to emphasize on the point, there is no promise has been made that reservation of 1% would continue. Such has not been pointed out by the petitioner here.
No. When the examination was held, that rule was there providing for reservation. What is the
notification?
Notification.
Notification. Yes, I
listen this.
It's my lord.
No. After the process commenced.
Yes.
The rule.
Game shall not be changed.
No. That's why they are saying that when they participated in the exam and when the result was declared, they thought that they will get the benefit of 1%, which you took away by amendment. That's
notification was given at this time. Submit the dates, my lord. notification for the admissions was given on 6/7/2023. But GO was issued on 4/7/2023.
Notice for admission, result was declared, no, before that.
That eligibility test was held on 7/5/2023. That NEET has nothing to do with this, my lord. NEET has nothing to do with this.
No,
That's all India's.
So when they appeared in the examination? The result declared in June.
13/6.
That
is all India examination.
Then what, your July date you are saying? July?
The government has issued notification, my lord. University has issued notification on 6/7/2023, my lord. For the admissions into this medical.
Admission.
Inviting application for the purpose of admission into this.
And before that it was amended.
GO was issued on 4/7 only, after 2 days. So, the arguments advanced by the petitioner that the rules, the game.
No, not rules of the game, legitimate expectation.
Legitimate expectation, my lord, this is date of issuance of the GO.
And therefore, rules of the game principle does not apply.
These are, there are 20 also in the same judgment. There are 30. There is 35. Same judgment which I am continuing to read, my lord.
There
are 20 at page number 35.
Yes.
In Sriji Sales Corporation Union of India, it was observed that the once public interest is accepted as a superior equity which can override individual equity, the principle would be applicable even in cases where a period has been indicated for operation of the promise. If there is a supervising public equity, the government would be allowed to change its stand and has the power to withdraw from representation made by it, which included persons to take certain steps which may have gone adverse to the interest of such persons on account of such withdrawal. Moreover, the government is competent to resign from the promise, even if there is no manifest public interest involved, provided no one is put in any adverse situation which cannot be rectified. Similar view was expressed by the Pawan Alliance and Casting Private Limited. So it was further held that the government would change its industrial policy if the situation so warranted, and merely because the resolution was announced in a particular period. It did not mean the government could not amend and change the policy under any circumstances.
Yes.
Well, if the party claiming application of the doctrine acted on the basis of the notification, he should have known that such notification was liable to be amended or resigned at any point of time, if the government felt that it was necessary to do so in the public interest. Well, at 21, this I read out, my lord. Therefore, my lord, the invocation of the legitimate expectation cannot be.
All right.
Next point, just I would like to add, my lord, this change, behind this change, my lord, central government from 2016 onward, thought it expedient in its wisdom to change this reservation from reservation to the adding grace mark. It is not the state government policy, my lord. It is the policy of the central government. Incentives and grace marks. My lord, it is not the state government. Central government from 2016 onward, insisting all the state government, not only the state of Telangana, almost all the state government to change its policy, giving it up the rule of reservation.
So it's providing reservation or grace marks is a matter of policy.
Policy. Yes, my lord.
Any case law.
My lord, no mandamus can be issued for enforcing this, directing the state government.
No, that's correct. He is not seeking a mandamus.
A direction in the nature. Direction in the nature.
The problem is that they don't read the petition which they draft. It is typed by somebody else.
Somebody else. These are the
That's why he has fairly said that I am not seeking a writ of mandamus. I am only challenging the rule, providing this thing. why have you this thing excluded NCCA from preference? That is what.
NCCA is the A, B, C. Millet A is applicable to the pre-metric.
1 minute. So, providing reservation is grace mark is a matter of policy and what?
No mandamus can be issued.
Ah.
On this proposition, Millet has submitted. Yes, sir. Grant you last judgments of
Issued to provide reservation.
reservation. On the direct right, Millet, it is not only these two judgments, Millet, from Balaji versus Champa or other, 1952 onwards.
Nobody is arguing right that mandamus can be issued. He didn't argue. But one thing, Mister, that what is they are challenging is that you have decided to give grace marks. Why have you excluded NCCA?
A is applicable to.
Where is that rule? Let's see now.
Please.
Rule.
Normally,
Amendment.
B is 75 GO, your lordship.
Page.
Page 19 will.
21.
Page 19.
Page 21.
Page 21 minute.
Grace marks.
Yes, minute. Page 21. NCC cadets who have obtained NCC certificate.
RDC, All Sainik Camp, so and so, whatever. This is camp and NCC B.
Category or participant Republic Day camp, RDC 7 marks, minute. Participation in all Sainik camp. Vayu Sainik camp, VSC so and so 5 marks. And NCC B certificate 3 marks.
What is what A, Y, no.
A is applicable, category A, NCC category A is applicable to pre-metric. Pre-metric.
After 12th, then B's, if you don't take part in NCC during winter, you get a base year. So they will go to 12. C is graduate. Once in winter, that later we go to get participate, taking part in NCC, they will give you this. B certificate, you will not get, only B will get. Eligibility for applying for any BS is telling us these people are E candidate. Because these are A category, they do not have. In intermediate, they did not take part of NCC. Only they take part up to 10th time.
Class 3. This is the description of the central government by NCC, my lord. May kindly see. This is the argument of the central government I am putting forth, my lord.
Now, Mr. Praveen Kumar.
Yes, my lord. Class this there are 3 of the synopsis on behalf of the NCC filed, my lord. They have stated like this, my lord. Certificate A is a basic certificate of NCC. Can be achieved by 9th and 10th standard of school. Certificate B will be issued to sincere and dedicated student who could strive so further achieve B certificate before completion of 12th standard. These candidates before your lordship are 12th standards. B is applicable. Whereas grace marks added to the NEET.
Candidates before us are candidates holding A certificate. Right?
Yes, sir.
A certificate. A certificates.
But they are entitled to have only B certificate, intermediate. Corresponding course is intermediate. Intermediate stage of B certificate only will be given by the NCC.
No, but one thing, this participation in Republic Day and participation in Thal Sainik Camp, with who
Will have added grace marks. They will have added grace marks only. 7.
Why 1 or 2 applies to inter? Which is the base. Within that NCC B applies to B. Even 1 and 2 also applies to B. Supposing I have an NCC B certificate that participated in RDC. You get 7 plus 3. No, total 7. If I have taken part in signing form, I get 5. Otherwise, I simply taken part in NCC during my intermediate.
Those who have participated in Republic Day will have 7 grace marks.
Also, like those candidates having B certificate participated in Republic Day will have 7% marks.
Yes.
Then those who have Sainik Camp 5% and those who have simply B certificate will have 3% marks.
Yes, these marks would be added.
But this is the you can yes. But this is what he's submitting.
This is actually they will have the right if they have certificate. There is no gainsaying. They will be added these grace marks if they provided they have these.
No, but you are giving only to B, right? This no provided to A. That's why they are here before us. A certificate it does not provide. That's the grievance. That's why provision is Article 14 and all that. This what has been argued, right? What else, Mr. That's all. Yes, Mr. Praveen Kumar. You have given that note.
The object of the NCC. I have given the synopsis. The very object. Primary object of NCC does not support a trained candidate to qualify the seek admission into undergraduate professional courses under 1% reservation. The primary objective are create human resource of organized, trained and motivated youth to provide leadership in all walks of life and always available in service of nation. To provide suitable environment, motivate youth to take up a career in the armed forces. And 3, to develop character, comradeship, discipline, leadership, secular outset, spirit of adventure, and selflessness of service among us the youth of service. It is only by building the responsibility towards the nation. That is the primary object. Now, next page, page number 3. There was a conference held on 2015, 1st July 2015. By Honorable Raksha Mantri, the paragraph 3. Since the NCC cadet devote considerable amount of time to pursuing NCC related to training activities compromising their valuable studies, it has been discussed in 21st Joint State.
Yes. State government were asked to.
Then,
and therefore the government has come up with respect of this.
Not the large number, the page number 6, page number 6, that was not conducted on 20th September 2022.
Yes.
The NCC address of the letter to Telangana, it is also addressed to the Chief Secretary. Paragraph 3, over a period of 6 to 7 years, it has been observed that this 1% reservation has led to serious misuse of various priorities given in the government orders influence of various agencies. To name a few, following are enumerated. The post MSET 2016, same cadets challenge No.1. Lots of aware NCC quota participation winning model sailing, which was conducted Sailing Federation of India, in which NCC is not a fielder team and ex-cadets participate in individual capacity. Therefore, to ensure overall merit, the government has not recommended. This aspect earlier considered by Honorable Justice Horizontal court, the division bench. Madam. Just only 3 relevant.
Yes.
With respect to priorities, Millard. Priority 1, note number 5. Then let's make the relevant is para 36, 37, 38. But this is not a case where the petitioner is challenging one of the rules of the game. All the petitioner is saying that the list of priorities is given by the NCC for the academic year 2015-2016 was already changed from the academic year 2016-17 onwards, and the same has been accepted in respect of technical education by state of Telangana and in respect of medical education in state of Andhra Pradesh. The government themselves do not have quarrel about the fact that they did not consciously decide to deviate from what was suggested by the NCC Directorate. In fact, NCC Directorate has prepared draft of the government itself. The government applied its mind and issued government orders. But what was done in the case of one court, the left out of the case of the court. The mistake was brought to the notice of the government by the NCC Directorate itself.
Which para you are reading?
Paragraph number 36.
Huh?
36 onwards, blood. Separate questions, blood. 36. Will not trouble us.
Para 30.
36, 37, 38.
Ah, yes, however,
Millard.
36, not a case.
Yes, Lord. Not a case where the petitioner is challenging one of the rules of the game. All that petitioner is saying that the list of priorities as given by the NCC in the academic year 2015 and 16 was already changed from the academic year 2016 to 17 onwards, and that the same has been accepted in respect of technical education by the state of Telangana and in respect of medical education in the state of Andhra Pradesh. The government themselves do not have quarrel about the fact that they did not consciously decide to deviate from what was suggested by the NCC Directorate. In fact, the NCC Directorate has prepared a draft of the government order itself. The government applied its mind and issued government orders. But what was done in the case of one course, the left out case was other course. This mistake was brought to the notice of the government by the Directorate. Then let's be next paragraph. Once the government had chosen to accept the list of priorities as given by the NCC Directorate without questioning the wisdom of the same or without taking the conscious decision to deviate the same, which they are very much entitled to. Any lapse on the part of the government, if pointed out by the NCC, should also be corrected. Therefore, it is not a case where the petitioner is challenging the rules of the game after participating in the game. But therefore, Mirad, basing on the Mirad, the large scale Mirad fraud, Mirad,
Yes, Mr.
I don't know what fraud is referring to, but so I cannot answer that. But the judgment which is passed on before your lordships is with respect to admission into engineering courses. There, my lord, they have continued this 1% reservation at para 7 at page 4 of this judgment. My friend should have been fair enough to inform your lordships that in the engineering stream they are continuing this 1% reservation. GO 14 is not amended. Only in medical stream, my lord, this amendment is carried out. And this judgment, my lord, has been reviewed. There is an order passed in a review application, which is also not brought to your lordship's notice. The judgment has got nothing to do with the case on hand, my lord, is my respectful submission.
Which review petition?
But I'll just give, I have requested my colleague to take out. I didn't expect my friend to rely on this because this is not relevant. Therefore, I was not prepared. I give the IA number, IA review number. By the time I complete my submissions, I'll.
Yeah, which time will you take? We have only some administrative work.
Only 5 minutes I'll conclude. I'll only answer, but the first submission was that The power exists, my lord, to amend. Therefore, wrong mentioning of my lord provision doesn't make it bad. My lord, I have no quarrel with the proposition of law.
Correct.
But my lord, where a rule is sought to be amended, they are saying power exists. Whether you have amended the correct rule or not, that's the question. Nobody is disputing, my lord, the power to amend. And 4.3c, my lord, does not exist at all. Numerical 4.3c is what is, my lord, sought to be inserted, which does not exist in the rules. There is no dispute. And the judgments, my lord, relied on by the learned additional advocate general, my lord, are part of the constitution bench judgment, my lord, in the Sivanandan's case, which I had given. All these judgments are mentioned, my lord. I'm sure, my lord, the page numbers only. And the, my lord, reference at page 23 of my compilation, reference 13 is one judgment and reference 24 is another judgment, where these judgments have been considered by the Supreme Court Constitution Bench judgment while dealing with the context of legitimate expectation. And the judgments which are relied upon are only 2 judge decisions, my lord. The judgment which I am relying upon is 5 judge and latest. These are 2015 judgments which have been considered by the 5 judge bench.
Oh, yes.
And my lord, there is no satisfactory answer to 2, my lord, important questions. One, my lord, I said that the rules, my lord, the Raksha Mantri's letter, my lord, is 2006, prior to framing of the rules. The rules were framed, my lord, in 2017. And my lord, there is no explanation why, my lord, after the Raksha Mantri letter, they started with 1% reservation. And why they have deleted now. No material is placed before your lordships, my lord, in support of that.
Yes. What
And my lord, finally, my lord, submission was made before your lordships for amendment of the interim order. My lords were pleased to modify that. May I invite lordships kind attention to that, my lord?
Now we are finally hearing it.
Well, because, my lord, I need to bring to the factual aspect of your lordship's notice. They sought, my lord, modification of the order on the ground that they have not yet begun the NCC counselling and the notification for which will be issued separately. 5 days later, my lord, they completed the counselling for NCC also. My lord, I have the list, my lord, of allotment. It would have been fair on their part if they would have brought to your lordships notice this fact. Having, my lord, invited your lordships to modify the order on the ground that they are not carrying out counselling. And
No,
5 days later.
Yes. If the petition is allowed, everything goes.
Has to go. But I can only submit, my lord, finally on the question of relief that can be granted in a case of this nature, which went, my lord, incidentally from our High Court to the Supreme Court. The question, my lord, is only the answer. Where, my lord, it is found out that I have been
Mark every day with his presence. Arguments concluded. Reserved for judgment. Yes.
.2. Incidentally, this has gone from our High Court. No question of compensation, no question of even next year admission. You take out the last person from the list and then give admission to the student. That is the judgment of the Supreme Court. I'll just pass on 2 copies before lunch.
All right, restitution.
I am obliged.
Yes. Thank you, Mr.
Obliged.
Heard, reserved for judgment. Yes. Arguments completed. Reserved for judgment.
Wait. Speak it.
Keep it like this only, so that everything is handy. 228 to 230.
The last matter, my lord.
Yes, Mr. So Mr. Rao, shall we hear you tomorrow? Because
Yes.
the administrative this thing. Otherwise, we could have sat till 5:30 and could have concluded. So you still want IA or 6th? We are hearing petitions. Finally, the whole bunch.
But it's for the petitioners, my lord, I have already advised it's not good to press for the, my lord, challenge to the GO and stick to the IA, my lord, to be considered as local because I'm, my lord, covered under your lordship's judgment. That's the
No. So you will be withdrawing the challenge to this.
Yes, my lord. If the IA is, my lord,
No. Not if and but.
Well,
You will have to make a stand. Here, either you are challenging the rule or you are not challenging. Choice is yours.
There is no rule as such, my lord.
No rule.
My cause of action is this.
No, but you challenge the rule, no? In the
amendment. There is no rule prescribing local candidate for PG admissions. They fall back on the president's order.
What have you challenged?
Amendment prescribing, my lord, reservation to the extent of
Statutory provision you have challenged, right? Amendments.
providing 100% reservation.
Correct.
Not definition.
Correct. So you are sticking up to your challenge to statutory provision. Alternative relief is that if I am given admission, if he is given admission, he will withdraw the challenge. That is up to Mr. Rao. You ask Mr. Prabhakar Rao if he gives the admission, well and good. But so then you want to press interim relief or what? Argue finally, because all other petitions we are.
True, I am aware.
You understand, right? So 6th of September you argue along with others.
This has been simplified by the counter, my lord. Additional counter.
So you are no, Mr. Rao, we want to clarify from you. Even though on 6th of September all other petitions are being heard finally, still you want interim relief to be considered for 1 day, 24 hours.
Subject to what your lordship, my lord. My my lord, prayer is to consider the IA, my lord. If your lordship feels, my lord.
Even if it is being heard next day, then we will see, Mr. After deciding the IA, we will adjourn. Other cases we will hear. What is this? I mean, like piecemeal hearing 24 hours, interim relief, then 24 hours. Again, what you will say? Supposing if interim relief is granted, you are fine. You will say post after whatever time. But supposing interim relief is rejected, we are yet to apply our mind to this. You will say that it be heard tomorrow. Please conceive, because everybody is being heard tomorrow. So in all fairness, you should agree for 6th of September. If for some reason it is not taken up on 6th September, you are perfectly justified in saying that please pass an order on my petition, interim relief.
Very well.
Right?
6th.
So shall we record your submission that similar matters are fixed for 6th? Yes. Therefore, it should be taken.
6th.
Mark the presence, Mr. P. Tirumala Rao, learned counsel for the petitioner, fairly submits that all other writ petitions in which issue with regard to validity of 32H,
yes,
32H of 2017 rules is involved. Is involved are fixed for 6th of September 2023. Therefore, his petition may also be listed along with the aforesaid batch and be listed on 6/9/2023 paragraph. He further submits that in case this court is unable to hear the, if for some reason, the court does not hear the petition finally on 6/9/2023, correct.
My position now is
Once you finish the argument, we will tell you something about night watchmen. Later, once you finish your arguments in this case.